ICSI IIP workshop. All the participants, I assume, are the seasoned professionals, qualified insolvency professionals, and having varied exposure and experience. So this workshop shall be an interactive workshop. We will discuss the problems, the experience which we are facing or which we have during our assignment. So, although we will present, we have prepared some slide for this topic, but it would be better if we could exchange our thoughts, our experience, our views in this very important and very good topic, like how to deal with the CoC meetings, conduct of the meetings and all. So I am presenting the slides here. Is it visible? Can someone confirm me?
Yes, sir.
Yes. Yes. Thank you. So today's topic is dealing with the CoC and CoC meetings. So first, before going into this topic, let us let us understand what is the objective of this workshop. So the objective or the area we will cover in the workshop is why CoC and its meeting are crucial. Understanding the composition, powers, and legal framework of the Committee of Creditors. We will also understand how to conduct the CoC meetings effectively and lawfully, and explore the practical challenges and how to resolve them. We will discuss with the wide experience we have in this. So let us go to the role of committee, this one. Just to have an understanding. So as you all are aware that section 21 subsection 2 of the code, which mandates that the committee of creditors shall comprise all the financial creditors of the corporate debtor. This all of us know. And the financial creditors have been defined, the term has been defined under section 5 subsection 7 of the code as persons to whom a financial debt is owed, and it includes a person to whom such debt has been legally assigned or transferred. We see in some cases or in practical life that some debt has been transferred or assigned by one financial creditor to other. So the financial creditors accordingly change. Then financial debt, we also have to understand what is financial debt. So it is defined again in section 5 subsection 8 of the code as a debt along with the interest, if any, which disbursed against the consideration for the time value of the money. So this is the three sections which those are concerned with the or relevant in case of financial creditors. Section 21 subsection 2 which mandates the constitution of the committee, and section 5 subsection 7, section 5 subsection 8 which deals with the financial creditors and financial debts. So this is what we all have to understand. Now coming back to the slides which I have prepared for the understanding. IBC framework. This just to have a rough idea about this. IBC was enacted in 2016. So must need not to talk about this. Aims to maximize the value of the assets, ensure creditor empowerment, and promote entrepreneurial revival. These three basic terms is the backbone of the entire IBC. So we all are working for maximization of the value of the assets of the corporate debtor. We all are working to ensure that the maximum value pays to the creditors who have invested in the corporate debtor, and revival of the corporate debtor who is under distress. So under these three things, the whole the IBC is revolving. And this also covers the corporate person, partnership, firms, and individual. So we are CRP, we are doing day by day, and individual has yet to be notified. Then key institutions under the IBC, we all know that is NCLT, NCLAT, High Court, Supreme Court, other courts, IPs, IBBI, and all are working under the overall umbrella of the Ministry of Corporate Affairs. So these are the framework of the IBC, and the most important and crucial part is the Committee of Creditors. The Committee of Creditors is the supreme under the IBC. Committee of Creditors is the decision-making body. RP is just a facilitator. So this all we will delve in or discuss in the forthcoming website slides. So position of the CoC in IBC structure. So if we can see that the Committee of Creditors is the supreme decision-making body. Under the IBC, once the CRP starts, we have to publish the public announcement. We have to invite the claims, and on the basis of the claims we collate the claim and form the Committee of Creditors in itself. So the Committee of Creditors is the supreme. The decision-making role has been assigned to the Committee of Creditors. That is why it is very crucial. So this committee is basically formed after collation of the and verification of the claims by the IRP during the first month of the commencement of the CIRP. And section 21 subsection 2, which I have just shown you, that it empowers it mandates the IRP to form the Committee of Creditors. This Committee of Creditors basically formed only with the financial creditors in certain exceptional circumstances, which we will also discuss. So let us find that financial creditors is the only members in the Committee of Creditors. They may be secured or unsecured. All major decisions, including approval of the resolution plans or decision of getting the CD into the liquidation, rest with the Committee of Creditors. CIRP and CoC fundamentals. So now we will discuss here in detail everything based on our experience and knowledge. So initiation of the CIRP through application by financial creditor or operational creditors or the corporate debtor itself to the NCLT. We all know section 7, section 9 or section 10. These are the three instances where the APC or OC or corporate debtor itself can apply to the NCLT by way of petitions under the respective sections to get the CD into this insolvency. Then the next phase, after admission of the CRP, IRP is appointed, and the duty of the IRP is to make public announcement and collation of the verification of the claim. Then constitution of the CoC, then conduct of the meeting and invitation of the resolution plan. This is our primary objective, to get the CD revived through this intensive resolution process. Then approval of the resolution plan by the CoC and more than 66% voting shares. And if the CoC is not able to revive, the liquidation happens. And very strict timeline is there. We all have to adhere 180 days with extension of 330 days for the liquidation. So this is all the timeline. Now, role of the IRP or RP in the CRP. So this is not, much which we have to discuss, but for the sake of understanding and to share our experience, we are discussing this. Takes control of the corporate debtors operation during the CRP and ensure it continue as a going concern. So here we have to share our experience. We have to discuss because the CoC is the decision-making body. We as RP or IRP do the everything, whatever we can do, but we may face the problem before the CoC to put up in cases where the CD is actively, working, his operations are still going on. So how to deal with that? So takes control of the corporate debtors. I would request the participants or to share their opinion or share their views in the cases where they have faced some problem or they are facing the problems in taking custody of the assets of the CD. So here we can, discuss these things. So anyone, please, what sort of problems or their experience? Because only giving the lectures and uh, presenting this will not serve the purpose of this workshop. We have to discuss very frankly the entire things which we are facing. So accordingly, we can, devise the strategy. We can write to the IBBI. We can submit before the IPA to uh, send the suggestions to further streamline this IBC code because it's a over revolving. So anyone who has faced the problem in taking custody of the assets, please share the experience. I will also share my experience here just to make this workshop interactive. Yes, please. Anyone?
Yes, sir, I have
Yes.
issue.
Yes, please, if you can on your video also, Mr. Gaurav.
सर जब मेरे को CRP अलॉट हुई थी तो
जी, जी.
द फाइल मैनेजमेंट क्लोजेस ऑल इट्स रजिस्टर्ड ऑफिसेस क्लोज द बिजनेस and not able to communicate. They will not communicate any of the mail. So it's the total procedure take approximately 30 days to communicate, to send communication with them, to ask the documents. Afterwards, we file an application under section 19 subsection 2 with the NCLT. And after a period of 1 more month, the NCLT decision come in favor of us. But still they resist themselves and they didn't provide any single document.
Okay. Which bench, Gauravji, you are? What was the NCLT bench?
It's Mumbai 4.
Okay. So this is the very common problem. All are facing. We all are facing. This is the very common problem. Once the CRP start and we get the order, we send the email communication to the suspended board that please provide the documents, informations, whatever. And in majority of the cases, they do not revert us. So in this situation, but the expectation of the CoC is huge. They expect the RP or IRP will do everything without any support. We have put up our effort very हमारी कभी कभी जान पे भी बनाती है ना, हम लोग जब ऑफिस में जाते हैं कहीं पे भी. So I am sharing my very first case I have been allotted was of the sugar mill. So in that case, I was to visit the factory or the sugar unit. I visited there. It was in somewhere around in Roorkee. So in Roorkee, I visited. So I sent the email to the suspended board. They did their part. They informed their person that see so and so people are coming to take the custody, and you have to deal with them. So this was very my first case in 2018. So I am remembering that at that point of time, since sugar mill is basically the farmers and all are there. So board informed them that see these are the people who are coming and they want to snatch their sugar mill and their dues will not be given, although there was huge due which was outstanding by the sugar mill to be paid to the farmers. So when we reached, we find that the huge mob was there. So if I would have entered the premises, there would be some mishappening. So I consulted my lawyer and all the team. This rested me, don't avoid this time, seek the assistance of the local administration. Only then you can, do. So by that way, I could manage the things. I visited the DM office and take the assistance of the district administration, and then very diplomatically I took the custody of the assets. So this happens. So what we have to do, we have to make the balance in taking the custody as well as to save ourselves also. So we need not to jump everywhere. We have to be very careful. So this is what happened in between, before the CoC meeting. Because in the first CoC meeting, you have to show what effort you have done to, perform your duties. So this is the main thing which we have to take the custody of the assets. We have to take the custody of the records. We have to communicate to the board, which Mr. Gaurav also told me that in majority of cases, this is not happening. So if it is not at all happening, what we do, we go to the MCA website and all, we get the public documents and all, because we have to put up before the CoC meeting after 1 month what we have actually done. Otherwise, the CoC will ask us what you have done in the last past 1 month since your appointment. So this is what we have to be very careful. Yes, sir. Any other experience? And let us discuss so that we could benefit from each other experience. Mr. Mishra ji, you are very very seasoned professional, I know. You are mute, sir. You are mute. If you could unmute and apply, yes.
Yes.
Yes,
Yes,
sir.
sir.
Yes, sir. You are sharing something.
Yes, because in Mumbai, because I am placed at Mumbai, so in Mumbai, yes, while taking over, I have not experienced any law and order problem. But otherwise, whenever we used to visit the place of corporate debtor, all these promoters, they don't allow us to go through any documents, etc. Whatever they will say, accounts, etc., they don't keep it. They used to have a one office. No, it is not a registered office even, wherein they used to consider, yes, sir, this is my office, and we used to do tally, and all other records are not there because 3 years back some file occurred also. On one ground or other, they don't provide us any copy regarding except some of the board meetings or minutes on sporadic basis. Means accounts, etc. Accounts, they used to say, yes, sir, it is tally, and I am providing you tally, but in tally, you won't find anything.
Correct,
That
sir.
is the thing. And
Correct.
so it is a common practice. But wherever in a few cases where operations are going on, in that case, yes, situation is little comfortable. But in rest of the cases where unit is closed or not much functional for last 6 months or so, they don't provide. They don't want to provide it because they one of the person doesn't do anything, they used to pose him as if he is the only person, sir, now things are accounts has become NPA, we don't have anything, like so on one pretext or other they used to try to avoid. And once suppose in that case, all these cases we have to file a case under section 19B. So once we file, in that case, hearing takes place for 2 months, 3 months, 6 months. Means 180 days will suddenly expire, and thereafter an order will be passed. Okay, promoters are being told that okay, you provide all the documents. Thereafter, liquidation happens. So you are still deprived of the documents.
And this Section 19(2) application got infectious.
Yeah, infectious, because it is heard after decision will come after 6 months or 8 months. So
Yes.
you can't help. That is the thing.
Yes, sir.
So,
Yes, sir. So in cases where actually we file the 92 application because we have to.
Yes.
And when the bench is hearing the resolution plan, so in
Yes.
one of my cases, the bench asked me, so you did the entire CRP without the document. You have filed this petition, Section 92 application, and you did the entire CRP. You got the resolution plan, you got it approval without the document. So I said, what we could do, whatever best we could do, we have done that. So this is the good questions we have to put up by the bench also, and we have to face that scenario also. So
Exactly.
yes, the purpose is this: within 1 month we have to work that much that in the first meeting of the CoC we have to at least put up certain things, that what is the status of the CD, whether the management of the CD has cooperated with us or not, and what the amount of the claims which we have received, how we have dealt with, we have verified what problems we could face. So these all are the work which usually we have to finish within the first before the first meeting of the CoC. So next, so legal basis na, so we again legal basis 21 section which mandates the CoC. Only FC will be the creators. We have why we are, I mean, repeating this, because it is repeating in the entire this IBC. And the one more thing which usually comes is the related party, because if you see that in most of the cases the loans to the corporate debtor has been given by the relatives of the corporate relatives of the directors of the CD. So this related parties are also uh, the financial creditors, though they are unsecured. But while admitting their claim, we have to see the claim form, whether they are related party or not. If they are related party, we do not assign the voting rights to those unsecured financial creditors. So here we will discuss the Robert's opinion by the FC also. So in cases you must have, I mean, experienced that when we admit the claim of the related party, CoC usually asks us why you have admitted their claim. So what we can do, sir, we have to admit the claim because the law itself said. So we see the persons who are the representative of the corporate debt, representative of the financial creditors, banks. They, I cannot say that they do not know the law, but they do not want to understand the law. They do not want to cooperate because of the some other limitations on their part, on by the higher officers. So they want to work in their own fashions. That is why we face the problems in the CoC. We will discuss this in detail also, what problems we are facing. So this related party, one of the problem which we usually face in this before the CoC meeting. They have never been given the power. Then the voting shares of each member is determined based on their proportionate financial debt owed by the corporate debtors. So here the voting shares we assign on the basis of the debt of the financial creditors to them. So this assignment of the voting share is to the financial creditors based on the financial claims only, the financial creditors claim. It is not related with the other claims also. Then section 23 specifies the RP must manage the affairs of the corporate debtor going concern. Here we face the problem before the CoC. In cases where the corporate debtor can run, or it's a recently closed operation CD, then there requires some funds at least to run the CD, but the CoC member are reluctant. They do not provide the funds because RP cannot take the funds from its own. They need the, even in case of interim finance, they need the approval of the CoC members. So here in some of my cases, I face the problem. So where the CD can run and the day-to-day expenses can be met out, but the CoC usually reluctant in providing the funds to run the CD. And if it's closed, its operations are entirely closed, then the chances of survival has gone. And the CRP continues for certain years up to the approval of the plant. So the assets of the CD deplete. So here we can share the experience which we are facing, where the CoC do not allow us to run the CD. Though we are knowing, we can see that if some funds is provided, if some fund is infused in the company, in the corporate debtor, then it can be revived. So in one of my case, it happens. I request to share the experience for the benefit of the participants. If somebody having this type of problems with the CoC member, then we can discuss how to, deal with that also. Yes, sir. Anybody face this problem that the CDs was working? It was recently closed. It required certain funds, but CoC denied that no, I cannot infuse funds. Yes, anybody, please. So let me say, in one case, the unit was working. It was, working before the 1 month of the commencement of the CRP. So it was a seasonal unit. So I put up the entire things before the CoC meeting that, see, this is the budget. We require this much of fund to run the CD as a going concern, and there is much chances that we can do that. So we put up the entire thing before the CoC. We discussed the things before the CoC, but the CoC decided that it will not fund. But as our duty, what if we can see that the CD can be revived by infusing certain funds, we must put up the proposal before the CoC. Now, ultimately, the commercial wisdom is with the CoC. If CoC decide that no, I cannot fund it, then your duty is complete. So this is what I have to share with you, that if you see the chances of reviving the CD, the operations of the CD or running the CD as a going concern, you must put up the complete budget and proposal before the CoC meeting and discuss it. If CoC denies, then it's okay, and your duty is complete by that time. And section 24 outlines how CoC meeting to be conducted, including provisions of notice, quorum, participants of CoC, and suspended directors. These are the section 24 outlines. We will discuss in details in the next slides. Then CRP regulations 18 to regulation 27 of the CRP regulations, which covers the entire timings for the meeting, the notice, the minutes to be shared, electronic voting to ensure transparency and accountability, and uniformity in the conduct of the CoC meeting. Then regulation 38, 30A and 12A regarding the withdrawal of the CRP. This is also to be dealt in the CoC meeting. And procedural formalities regarding the settlement are all the procedures which we have to taken care of. So section 12A, section regulation 30A, we all must have dealt with, because one or other cases we have ended, there must be settlement also with the FC. So here we the here the intent of the FC is very much important, because every CD want their case to be withdrawn. And if the financial creditors are intended to get into the settlement with the suspended management, that only in that cases it is happening. Otherwise, we have to conduct the entire process. So now we will discuss in detail how this CoC is constituted. So only the financial creditors can be the member of the CoC. In some cases, the amount of the claim of the operational creditors are much more higher than the financial creditors, where the OCs felt that they have been or they are treated inferior to the financial creditor, because let me quote that in some cases the claim of the financial creditor was only 50 lakh and all the operational creditors combined the claim was 5 crore. But the decision making is with the financial creditors only because of this regulations and sections. So in that case, the OCs are feeling that they are being oppressed. But the situation is this: whatever the amount of the FC or the financial creditor, only the COC will be formed by the financial creditor. The OCs may be the participant. So in that scenario, the operational creditors feel that they are being oppressive and they are not being taking part, because the law itself says so. We have to be caution and we have to be careful and we have to tackle the operational creditors in a very decent way by quoting the provisions and all. Only the unrelated financial creditors are allowed to vote in the COC decision. So here we can see that the financial creditors who are unrelated only, they have been given the voting rights. Other creditors are not being given the voting rights. And in absence of the financial creditors, the operational creditors or the representative may form a committee. So here we want to share my experience, and as well as I would request to share your experience also. So in cases where the debt of the operational creditors or the claim of the operational creditors are more than 10%, and there are certain operational creditors, say 4 or 5 operational creditors, then we have to we have to make authorized representative on behalf of the all OCs to only one OCs. How you are you, I mean, faced any problem in this, or have you share your experience that what process you have adopted in selecting the authorized representative among the OCs? Anyone, please?
Yes, sir. I think this is the area where I have experienced a lot, because the case was the reso plan was submitted, and I joined that as a RP from fourth COC meeting. In initial first three COC meetings, operational debt was more than 10%. But since in the initial two meetings, no operational creditor attended the meeting, and then the RP had a considered view, he has recorded also, that these are the financial creditors and 5 common parties creditors who are financial creditors as well as operational creditors. He recorded that they will be considered as a representative of operational. And I continued and followed the practice. Subsequently, promoters also submitted their plan. Means CD is basically promoters of the CD also submitted the reso plan, since they were MSME, and their plan was rejected by COC, and the plan approved by NCLT was some other person. It's not the promoter. Then initially, during the approval of plan by NCLT, IA was filed by the promoters, one of the these maybe close with operational creditor, that since RP had not called me, the plan is rejected and RP may be sued or may be penalized. Fortunately, NCLT, since their share was whosoever has filed the IA was 1% or 2% of the total debt. So NCLT passed the order in my favor and approved the reso plan. And other lot again went to NCLAT for appeal. In appeal, the order was passed, no, all these RPs used to do, they don't care of the operational creditors. So that's why, though they did not reject the plan, they approved the plan that at this juncture we can't do. But yes, RP I am penalizing by imposing the penalty of rupees such amount or so. So immediately I filed an appeal in Supreme Court. And meanwhile, as normally happens, IBBI issued a notice. I replied the notice mentioning the position that it was my position and my role was I only continued. And though the section 24(1)(c) is also little confusing because in section it tells that notice should go to each and every party, and whereas in section 24(4) says that this one representative may attend the meeting. So who will do this process of one representative is there or not, whether they have chosen of them, whether I am bound to issue every notice. They have NCLT only passed the order that notice should be issued to all the operational creditors where these operational creditors are more than 10%. In my case, number of operational creditors were 273. So I contested before IBBI as well as before Supreme Court. So fortunately, in Supreme Court, my appeal was admitted and this NCLT order was stayed. But meanwhile, after issue of CoC's notice, IBBI used to not allow you the AFA, etc. So for 6 months or so, I faced that music. Thereafter, fortunately, based on the stay granted by Supreme Court, IBBI has taken it back. Okay, considered disposed of since case is sub judice. So this way I could able to. So in there that section 24(1)(c), I find that little means cumbersome because if operational debt is 10% or more, then you are supposed to issue notice of each meeting to every operational creditor. Once you did not able to comply with, anybody can go to court and it will tackle the entire process if this plan is likely to be approved or not. So that is the experience I had. So that I say. Fortunately, everything went well, and IBBI also, based on stay granted by Supreme Court, did not do anything and disposed of the notice granted, the notice issued. That is the case.
Yeah, that was good. But otherwise, sir, how to comply with this? Otherwise, so
sir, in that case, what I feel that this initially you have to, from where claim have been received, you had issued, you have to issue notice for first meeting at least. Thereafter, you means whosoever out of 10%, whoever is the highest amount. So if you, because you will not, they will not sit together themselves, and it is liability finally lie on you. So what you need to do, first, whosoever the share is the highest one in the operational credit, from your side, you consider them that none of them has appeared. So I am finding him the highest one, and he is the operational creditor. In case he doesn't appear, then you have to again go for the second one. In my opinion, because in before the inquiry committee also, I told that this should have been happened, that normally if issuing notice to everybody is not possible, and section 24(1)(c) those say that you should issue notice to every operational creditor, but simultaneously in section 24(4) they say that only one representative. So whosoever is the representative, if the operational creditor choose themselves, okay, you have to go with them. If they don't, then wisdom lies upon you. So what you will do, being a professional one, we have to, whosoever is the highest one, 1, 2, 3, 4, we may choose if anybody is willing to attend. So we used to issue them, and if it is accepted, then I think the law is complied.
Correct, sir. Because the law is silent over it.
That's
Nothing,
right. That's right.
nothing has been written in the code or the regulations.
Nothing. Yes.
But if you see the process under the in the real estate matters where the AR has to be appointed.
Exactly. Exactly.
So
That is
it
all.
says above 10 class of creditors, the AR
Yes.
to be appointed. So
Exactly.
can we, can we assume that in case the OCs are less than 10, we should invite all the OCs in the CoC meeting?
Yes, yes, it is up to the RT. I think when it is
take the
feasible,
logic
very
from,
well.
yes, take the logic from that ground. So if it is
Exactly.
within 10, then we invite all, and if it is all more than 10, we can start the process of choosing the representative. And for that, my suggestion is that we invite all the 10 in the meeting and ask them, you yourself decide whom you want to be your representative instead of I decide. And citing that these are your amount of the claim, the highest one may be the ideal one, as also suggested by you, who can be the AR for all the OCs, and others maybe choose depending on their understanding. So that process can be
That can be, it is better. Though practically possible to call all of them, we should. No issue. 10 or maybe even more than that.
yes.
Possibly 10 or 15 or say, which can be manageable.
That
We
can be
call.
accommodated in the meeting.
Yes.
Otherwise,
Yes.
there will be,
Yeah, it will be a chaos only.
Yes, sir. Yes, sir. Yes. So, any other views or any other experience, learned members, if you could share us? Well, thank you, Mishra ji, for sharing your good experience to us. Any other person?
Thank you, sir. Thank you.
No. So, we are on this absence of financial creditors. Operational creditors and their representative may form the committee. So here if there is no FCs, कोई भी नहीं है FC, तो जो OCs हैं वही ये बनेंगे अपना कमेटी ऑफ क्रेडिटर्स. In that case, actually the situation is more cumbersome because they only think of their interest only, and furthermore they are not regulated actually. Banks are some or other out whatever they say, how they treat the entire process, but overall they have some accountability over their accountability for the organization. But in case of OCs, they are only the members of the CoC. If there is no FC, then conducting the CoC is more cumbersome. I can see I have experienced some problems in some of these CoC meetings where operational creditors are the members. So they only approve the resolutions which they suits to them. Otherwise, all the resolution got rejected. They are least concerned with. Although FC in some cases do the same behavior, but in case of OC, this is more problem. So here we have to be very, I mean, submissive or whatever you have to show your caliber to do the things to run the CRP according to the law. So this is the most cumbersome cases where only OCs are the CoC member. Then home buyers are considered financial creditors and representative collectively by an AR. So in this case, sir, the decision was there. Just a minute. So if you remember that earlier there are only two class of creditors, FC and OCs. And after the Pioneer Urban Land and Infrastructure Limited matter, this new class of creditors concept was emerged. The home buyers who are the main source of funder to the real estate projects, the home buyers was not having any say in the CRP because they were they were not treated as the FC. But after this Pioneer Urban Development Infrastructure matter, the Supreme Court, thanks to the Supreme Court who took the decision that the home buyers, there must be another separate class, and that is why this home buyer class was created. So these home buyers are the unsecured financial creditors. They have been given the similar rights as of the financial creditors, except they are unsecured because they do not have any assets mortgage in their favor. So there are hundreds or thousands of home buyers in real estate matters. So how to tackle this situation in the CoC meeting? Because if 1,000 or 100 persons are attending the CoC meeting, there would be complete chaos. That is why the concept of authorized representative was introduced. In this scenario, the IRP has to identify whether there is any class of creditors at the time of commencement of the CRP. Then there are basically two class of creditors. First is deposit holders and second is the home buyers in real estate matters. So they have to invite the three names from the insolvency professionals among the insolvency professionals, and they will publish in along with the form A that to the at the time of inviting the claims from the stakeholders. Then accordingly they choose the authorized representative. That authorized representative shall be is the member of the CoC on behalf of the all the home buyers. So that is how the CoC is controlled for the home buyers. So financial creditors, one the bankers or the financial institutions, and other is the home buyers, that is the class of creditors, and other is the deposit holders, that is also a class of creditors. So there may be two class of creditors in the CoC meeting, represented by the AR. Everybody knows. So this way, the CoC constitute. Then we decide the voting shares. The voting shares are assigned based on the percentage of the total financial debt owed to each financial creditors. So whatever the financial debt total is there in the at the time of collating the claims and constitution of the committee of creditors, we assign the voting shares. Each CoC member voting share is equal to creditors claim total verified financial debts into 100 divided by the formula is there. So everybody knows. So I'm not going into this. This is just for the sake of understanding. We have mentioned here. Decisions like approval of the plan or liquidation requires qualified majority vote of 66%. Total voting is proportionate and dynamic, subject to the claim modification and NCLT rule. So here I can share one of my experience where the home buyers, in case of home buyers, the AR has to vote based on the percentage of the majority vote received in favor or against of any resolution. So I am sharing one my example where the home buyers were very much dissatisfied with the. I was acting as an AR, or still I'm acting as AR in that matter. So what happened, sir? Dear, in one resolution, more than, if I remember correctly, more than 90% was not participate in the voting process. More than 90% home buyers have not participated in the voting process. 4% voted in favor of the resolution. 3% voted in favor of against the resolution. More than 3%. So more than 4% was in favor of the resolution. More than 3% was against the resolution, and around 2%, 2 to 3% voted as abstain. So here the problem arises. So I could explain the scenario. So
Yes, sir. Very well. Kindly continue because it is a critical situation.
yes. So it is a critical. So all the home buyers catch me. They said you did the wrong. What I did in this matter, I approved the resolution based on the percentage I could get.
Yes.
So they said, see, more than 90% did not vote. More than 2% was absent. More than 3% was disagree, and only 4% was agree, and you have approved the resolution. So in that case,
What choice you had? No choice. Because you
I
have to
had no
either
choice.
to either side, either approve or not approve.
So what their logic was that 3% was in disagreement, and more than 2% was abstain from voting. So more than 5% was not agree total, and only 4% was agree. Why you have approved the resolution? So I have to, and it was the tough time for me to get all them convinced. I
Exactly.
and one insolvency professional was among those home buyers also, sir. So in that
Okay,
case, it
okay.
is very difficult na, to convince all those. So we discussed a lot in this matter, and finally they understood that yes, I did the right thing. So there is no problem in that on that. So any other person felt such difficulty, faced such difficulties in the voting process? Because in the real estate matter, it happens actually. Because most of them do not vote. So this is what I want to share with you, my experience.
Because as per my opinion, a resolution will not wait for you to get a consensus. They will not wait. Either they have to approve or disapprove. The only thing.
Yeah. Sir, so the another thing is this. Actually, we have to give three options. One, approve. Second, disapprove, and third is abstain from voting.
Abstain from means you should AR should also be allowed to at least go for means abstain from.
Abstain. So on three
Yeah,
options, I have to publish. I have to give to the voters, right? So
exactly, exactly.
so this is the scenario. Well, in this scenario, actually, what happened? The people do not understand what is the
Mm,
value of abstain from voting.
you are very right, sir. Because due to your problem, because this is the area where something need to be done. Because in case 90% had not attended the meeting, you have no
Correct.
option because that meeting CoC meeting was scheduled to be held, and by that time you have to go either side. You have to take a decision. If 70%, 80% are not attending the meeting, what you need to do? You should also abstain from and not attend the meeting. What is the option you have? And since you have no option, you have to attend the meeting. If you, in case you will not attend the meeting, everybody finger upon you that you have been paid for that. Why you did not do?
Yes. Correct, sir. So in that case, at least the abstain from voting person maybe, I mean,
Should also be. Should also be. Yes, it should be.
I don't think it may be right or wrong, but there has
It
to
should be.
work out. Otherwise, the problem is that some people do not understand. They voted, they abstain from voting. They think that ठीक है मैं तो neutral हूँ मैंने कुछ नहीं
Yes,
किया
yes. I
है ना?
think, sir, in this area where there should be a threshold limit to approve any resolution, 5%, 10%, or whatever they think appropriate. If it is there, then certainly then they will attend the meeting. Home buyer who has not attended, because finally ball has to be in their court and they have to face the entire thing. We are only working on behalf of them.
Correct, sir. Correct. Very correct. And another problem or another experience I can share that in real estate matters, if you can see that certain usually there are three class of home buyers.
Mm.
One who is having the registry and possession.
Yes.
Another who are having the possession but the registry has not been executed.
Yes.
And third, where they are neither having the possession nor the registry, the project is completely unfinished. So there are three types of creditors. So if you see if the registry is not executed, the assets still in the name of the corporate debtor.
Yes.
And if you are having the possession, then again the assets are not in the possession of the corporate debtor because in the real estate matter, possession is the actual.
It also happens.
So in these circumstances, the usually the RP what RP did or what RP does that they do not assign any voting share in case only registry is incomplete and possession is there. So they do not assign any voting share.
Mm.
But the here the dissatisfaction from the home buyers arise that what they say they say that their rights has been hampered by not assigning the voting share. So the contention from the RP side is that if I would assign the voting share, I have to take your asset into the resolution plan because it's the assets of the CD. I am giving you a favor that I am not including your assets into the assets of the CD. That is why
Exactly.
I am not giving you the voting share. his contention is absolutely fine.
Right.
Very correct. But the home buyers, they are very innocent, I can say.
Hmm.
They have not been given the full facility in the real estate project, like they have not given the parking or club. Only these two things usually lack. Otherwise,
Becomes
they have
delayed. Yes,
given the.
yes.
So they are saying that my money has gone and you are not giving me the voting share. The financial creditors are there are deciding as their own. So this is very fair. I think there is no problem if they are doing. If they are voting as per their. Uh, as per their wisdom. Then what is the problem? So here the problems actually happen. So IBPI or the regulator must come up with the explicit, express regulation that this voting share has not been assigned to, yeah, may not be assigned to, or shall not be assigned to so and so home buyers who has been given the possession, but registry is pending. So the dispute will be, finished. But since 2 to 3 years have been gone, but no amendments in this regard had been sent, and we are facing the problem in the CoC meeting also because of this.
I
So
think recently a judgment has come that wherever the possession is with the home buyer, in that case, RP cannot take possession back. I think 6 months or two something.
yes, sir. Yes.
Yeah.
Yes.
So in that case, there should not be wherever any home buyer has the possession, and generally he should not be allowed to a voting right, because you cannot eat the egg and have it in hands too. So once
Correct.
possession registry may not be there also. So similarly, okay,
Yes.
proceed, sir. Thank you.
So, but it's time now that regulator must come up with the
Must.
express regulation to, tackle the issue. Although there is an amendment recently last year that the RP may execute the registry of the incomplete real estate project. uh, But in that case also RP is not inclined to execute the registry even though possession is there, citing the reason that the project is incomplete. And in case of incomplete project, who will bear the burden or who will bear the responsibility in case of any mishappening? So that is also not working. Now, next role of the CoC in CRP. Here we have to discuss again, act as the key decision making body during the CRP under the IBC. So here let us discuss the first meeting, first meeting of the CoC. In the first meeting of the CoC as a RP or as an IRP, we have to place certain resolutions for the approval or for the decisions of the CoC members. The maximum decisions which are passed by the majority votes, but there are certain decisions where we require 66% voting shares. So the very first decision we have to place before the CoC meeting is that to take on record the constitution of the Committee of Creditors. Here we face the problem in the amount of the claim, basically. So amount of the claim, the FC submit us the claim based on their books of accounts. Sometimes they submit the claim as on the date of submission of the claim instead of as on CRP commencement date, because the claim has to be submitted as on the CRP commencement date. So here they insist the RP to admit their all the claims, the entire amount which they have claimed. So in the first CoC meeting, we first note of agenda, which is to take note of the constitution of the CRP, then to replace or continue of the RP. So here we want to share your views, sir. We want to your views on this to replace or to confirm the appointment of the IRP and ARP. I think every one of us has faced some or other problem in this resolution. Anyone, sir? If you can share your view on this resolution and how to deal with this. So let me share my my experience on this point. See, in the first meeting of the CoC, the resolution which we have to put up for the confirmation of the IRP. Here, usually we ourselves put up as the eligible candidate to be appointed as the RP, and we also have to give the choice to the committee of creditors that in case they want to propose the name of the some other IP to be as RP in this matter, they can do that. So what happens, sir, is some of the cases, the RP, the CoC defer this agenda for the next meeting of the CoC. In many times, because they say they are not competent to decide on this matter. So what is your view or what is your experience, sir, in this matter? What we should do?
Yes, sir. In fact, normally wherever what I experienced, wherever the case is initiated by any operational creditor, wherein banks means nationalized banks, other banks are used to be financial creditor. So in first meeting, this appointment agenda they used to defer. And earlier also, in one, I think 5-6 years back, the State Bank has rejected the panel also, and they used to go because they defer the agenda. Then they have a JLM meeting wherein they propose to appoint another RP. Normally, this practice they used to follow. Means this resolution for confirming the IRP as RP never take place in that case. But wherever financial creditors used to initiate the insolvency, then possibly because that particular financial creditors may be having the majority share, in that case, RP used to become the IRP used to become the RP. So this is the practice they used to follow. And here we, as a RP, we can't have much means things to contribute because financial creditors finally they are the major stakeholders like they used to be. So normally it happens.
Correct, sir. So what we can, because of my past experience in this matter, we have to discuss now before the meeting, I think, to
Normally, this
overcome
should
the
be.
issue, because otherwise at the meeting, we all of a sudden came to know that this is going to happen. But if I mean, communicate to the FCs or the members of the CoC well in advance, what they are going to do, how to do this, because if you, I mean, deal with them, or if you can spoke to them, communicate to them beforehand, then there are chances that they could take the decision from their higher authorities based on. Okay. So in some cases, I have avoided this deferment by proactively dialogue, getting into the dialogue in this regard, or any item in the same way, any item. Now you have to, I mean, feel the nerves or sense the nerves of the members, how they are going to do in that agenda item. And otherwise, with the recent amendment, after 48 days, if the IRP is not appointed or confirmed, then he will act as the
Normally he used to act as a till the new
RP.
RP is appointed. That's why I told that. In that case, I was joined from fourth CoC meeting because they
Correct.
used to. First one was appointed by through on the basis of operational creditors proposal. Then bank used to go 2-3 meetings. They used to take in that way only. So, and finally, the 80 days, 180 days expire has to expire. All these things are these are the
Correct.
contradictions of each actions of.
So, and the if the same agenda is not, I mean, approved, or we can say that this is rejected, not deferred, actually rejected. So,
yes,
shall we put up the same agenda in the next meeting if it is rejected?
Because that agenda of confirmation, in my opinion, has to be put up until and unless there is a new agenda for appointment of another RP.
Correct, sir. Correct. So my view is the same also, and for that we, I mean, send the notice in advance and writing that this is the provision, and we have to put up the same agenda, or otherwise you propose the other RP. I have no problem. So by this way, until the resolution for the liquidation is not passed or the new RP is not appointed, we have to put up the agenda in each of the meeting.
I think that is the duty of RP. In
RP.
case he will not put up, then they may say that why you did not put up.
Yes,
Because
sir.
you wanted to continue on the pretext of this our in decision making, not decision. So we have to put up.
Very, very correct, sir. Very correct. Decide whether to continue the process, replace the RP, or initiate the liquidation if the resolution is not viable, only after getting majority of at least 66% voting share. So another agenda item or another area where we usually face problem, because in some cases there is no asset in the CD, sir. And in the very first meeting, CoC want to get the company into liquidation. In the very first meeting. So usually we pursue to the members of the CoC that, see, this is the very first meeting. Please do not do this. Otherwise, we have to show some effort now. We have to do something for the to get the CRP, get the CD resolved. So, but in the other meeting, the second meeting is usually the agenda for liquidation passed, where there is no assets and there is no sense of getting the CRP continue also. So here we have to, deal with the CoC very friendly and get them understand the law. And in the first meeting, we request them not to put any agenda for the liquidation. But in the second meeting, based on the informations collected during the CRP, they can put up the agenda for the liquidation. So this is regarding the liquidation agenda in cases where there is no assets. Then under section 25, under regulation 25, e-voting is mandatory for decision making outside the CoC meeting, which ensure transparency, convenience, and timely decision making. So, sir, here in some cases, although e-voting is mandatory, or I can say the voting is mandatory, but in some cases, the CoC member, just to save the meager amount of e-voting expenses, they say that send the resolution over email. I will decide, and then you can, monetize in the minutes and share the voting result. Sir, what to do in that cases? How to deal the CoC in those matters where they insist, no, not to start the voting, send the agenda through email, that is also e-voting. How to tackle, sir? Have anybody faced such problem?
We have to only say, sir, because this is e-voting is only cost incurring. So kindly, finally it is going to be burden from the CoC and the stakeholders only. So please, and so many times in one or two cases, I have to extend for months this voting period. So that not only happens and can't help, because we have to, in case of e-voting, and they used to seek approval from their higher ups, and until approval comes, they cannot vote. They only request, okay, sir, kindly extend, please extend, please extend. That is a practice.
Correct. So, so my question is, sir, they insist to send the resolution through email only. They will take the decision on the email just to save this 2,000 to 5,000 rupees of e-voting charges.
So,
Yes, sir.
I think this should be accepted. There is no harm. Basically, ultimate purpose of the process is to get the clarity that who are the participant, they voted in favor of this so and so thing or against. So if we are getting this by saving that, okay, 5,000 cost also, it is worth. Ultimately, we are going to complete the purpose.
Here I agree. Shravan sir, I agree with the opinion of my friend, that in case all are finally stakeholders have to take care, and in case they are sending us email that we should send a resolution through email and they will concur or accept it, then we don't have any problem otherwise.
Correct. In few cases, I practically did this thing and it is accepted.
So,
though it is not inbuilt in anywhere in the law.
You are right, sir. In one of my cases, I did that, but I faced certain problem which I want to share before,
Very well,
so that you could also not face the problem. One, there is no, no closure of window in case you send the resolution through e-voting. They send the resolution approving in one mail and they can again, oh, sorry, I'm sending the right one. First. Secondly, you have to follow day by day. Although you follow in the e-voting process also, they are not replying, sir. The problem is this. I am asking that please vote it because there is no timeline. Na? So this is the second problem I face.
So basically, in such situation, when sending the email, we can put the window that okay, within 72 hours, if you reply, I will take into account. Otherwise, right to vote will be forfeited.
No, but they are the majority member, na, sir. And you have to complete the voting. You have to take the vote either this way or that way. Then you have to continuously follow with them.
But
Sir,
time
you are very right. Normally, what I do, because I have faced this type of problem a lot from the banks, it happens. And so, in that case, I am every time issuing that resolution to all the participants, one thing, and giving them certain time, 72 hours, after discussing with them, sir, how much you require? Please tell me first. So, 72 hours, 48 hours, whatever. Normally, 48 or 72 hours they used to take. And if they don't, and the last day also, we have to give a call to them. Please, now expiring. Once it is expired, then we show our helplessness. Sir, law doesn't provide us, so we can't do anything. Now anything, whatever will happen, it will happen in next year.
Correct, sir. So this is the inherent problem of sending the resolution through email.
Yes, yes.
So some problems may be, minimized through e-voting process only.
Exactly.
So, but we have to, I am also doing the same thing, Mr. Pramod. There is no harm in this, as you rightly said.
Means, sir, we have to accommodate every person, stakeholders, to the extent our skin is safe, frankly speaking.
Correct, sir.
We should not be held anywhere responsible. That is that call we have to take.
Agree, sir. Agree. Thank you. Then, sir, financial cater versus operational cater, although we have discussed, but again, because now we have discussed in part, we have prepared these slides for the more discussions. So the things may be repeat. Please bear with me. So legal definition given in section 5 subsection 7 of the FC, and regarding the OC definition is given in section 5 subsection 20 of the IPC. Then CRP filing section 7 in case of financial cater and section 9 in case of operational cater. Member of the CoC, normally OCs are not the members of the CoC, they are only the participants. If their claim amount is more than 10% of the all debt. But in case of there is no FC, the OC shall be the members of the CoC. Then, sir, voting rights in CoC, explain. Full voting rights FC having, but in case of FC and OC, both are there in the CoC. OCs are not having the voting rights. Can attend CoC meeting? Yes, automatically. Member of this CoC are the FC, they can attend the meeting. Then must be treated as fairly can raise the objections. So role of the role in the resolution plan, OC also can raise the objection, but this is the complete power of the CoC members who are basically the FCs who can vote in the resolution plan. Then priority in liquidations, higher as per sections 53 waterfall mechanism and lower in case of OCs. Then power of the CoC, coming to the most crucial part, that is the decision making power and other key powers, implications of the CoC powers. So we have written some powers that is basically the entire exercises for the resolution plan, whether to approve it or not. So section 30 subsection 4, which exclusively authorize the committee of creditors to take the decision whether to approve the plan or not to approve the plan. There are certain conditions, things which all has to be fairly discussed before the CoC. in the CoC meeting. If the resolution plan is not viable or commercially feasible, then CD can go into the liquidation by the with the certain requisite percent of voting share. Then power to replace and appointment of the RP is rests with the 66% majority vote, and may approve interim finance for sale of the assets. This we will discuss. So let us have, sir, 10 minutes break for tea. Then we will continue. Is it fine, sir? अंजलि जी आप हैं?
Very fine.
Fine, sir.
Yeah, yeah. After 10 minutes break, 10 to 15 minutes, we will
Thank you. Thank you.
Yeah, yeah. Let's start.
Yes, sir.
Yeah. So I in chat there is one query. If a CoC member abstain from voting in CoC meeting under the IBC, what would be the treatment of their vote? CS Drupal. Go. Are you there, sir? Mr. Drupal, CS Drupal is there. You have raised one query. I think it's not joined. We'll take this query for later. So, just a moment. Let me share my. I'm sharing. So, I was here. No? Approve the plan or reject the plan. Then authorize the sale transfer of non-core assets. Yes, I was here. So power of the CoC. So let us first take this provision of section 28. So section 28, approval of the committee of creditors for certain actions. So we will discuss one by one. Section 28. First, the resolution professional RP shall not take the following actions during CRP without prior approval of the committee of creditors. So as RP, we have to very vigilant, very cautious, not to take any actions regarding the points or activities which are mentioned, prescribed in section 28. First, to raise the interim finance beyond the limit decided by the CoC. So this raising of the interim finance beyond the limit decided by the CoC, in case the CoC has decided any limit, then raising the finance beyond any limit are not permitted without the prior approval of the CoC. Can we raise the interim finance without the approval of the CoC? Any view?
No, sir.
Yes. So then
No.
how can we run the process without the finance? Without getting any contribution from the CoC member, how can we run the CoC, the CRP?
Sir, from the funds available in the company or the interim amount that is granted by the NCLT, the interim amount.
Advance amount, as per
That
the.
amount, sir.
Apart from that, तो बहुत छोटा सा होता है, 1 लाख रुपए का अमाउंट, 2 लाख रुपए का एनसीएलटी देती
आपको सर 10 लाख का, जैसे रिसेंटली 10 लाख का ऑर्डर आ रहा है सर.
है. Great. Great. So actually, now we have to fund from our own pocket. Because
Yes,
we cannot we cannot raise the interim finance at our own. So we have to fund from our own pocket the entire CRP expenses. Although we request the service provider not to insist us for payment till we get the funds from the CoC members. Otherwise, in certain cases, we have to, pay from our own pocket to run the CIRP. Otherwise, the entire this process will stop. And the most important activity for this CoC member is to pinpoint the expenses and approve the expenses incurred during the CRP process. That is the CRP cost. So discussion, whatever discussions is required to be there in the CoC meeting, this is the much important area about this CoC member to discuss and try to, not to approve or defer this item for. Then in that case, how we run the CRP process? Raising the interim finance is prior approval, that is fine. We cannot raise the interim finance. Then create security interest over the assets of the corporate debtor. We cannot mortgage the assets of the corporate debtor for taking the money against the security of the assets of the corporate debtor. If we want to do that, we need the prior approval of the CoC. And that is all in the CoC meeting. That is why we are discussing. Change the capital structure of the corporate debtor. We cannot change. I think there may be any circumstances where the capital structure of the city may be changed apart from the approval, apart from the outcome of the resolution plan. Is there be any scenario? Sir, any view on this? Then why this is there?
Bonus record date.
Yes, sir.
If
Yes.
there is a bonus record date after the CIRP initiation.
After the CRP initiation?
There is a bonus record date. Bonus option.
Okay. Okay. So bonus record date, capital structure will be changed in that scenario. Correct. But that has to be prior approved by the CoC, right? Take. So we cannot raise the money now by changing the capital structure. Who will fund the company if it is in CRP? So capital structure, normally the situation may not arise. Then record date in ownership interest of the corporate debtor. Record change the ownership interest. That we also do not do. Correct. Then authorize debt transactions from corporate debtors account exceeding limit decided by the CoC. Debit transaction, sorry, not debtor, debit transaction. So here, what we do, sir? Do we get any resolutions put up before the CoC for debit transactions during the CIRP? Any amount? If suppose certain amount is lying at in the accounts of the corporate debtor, do we have to pass the resolution for that? For even making the payment of 1 rupee also. What is your view, sir? Or this is only for capping? Gaurav ji, your view?
Sir,
They,
I didn't get to you, sir. समझ नहीं आया sir question.
Sir, authorize debit transactions from corporate debtors account exceeding limit decided by the CoC. So do we need to decide any limit that beyond that we will not, make any debit transaction? Generally, we issue the checks for the CRP expense cost for making the payment, right? So it says that RP shall not enter into debit transactions of the CD beyond the limit decided by the CoC. So if there is any limit, then the RP will not issue any debit transactions, is not authorized and to issue any checks or instructions for debit transactions from the account of the CD. If there is no limit, then he can do anything. Is that so, or do we specifically need any resolution to be put up before this CoC meeting?
So we need a resolution to put up before the CoC and let them know what are the probable the fee for particular task or whatever we have to do, and approval is required from the CoC.
So regarding this, Mike. So usually, I mean, we do not put up such resolution for the, for the certain amounts, for a small amount. But for higher amount, we have to be cautious. So this we need to be taken care of, correct? Then undertake related party transactions. What does it mean, sir? Undertake related party transactions. What may be the possible transactions which are prohibited? In case of running company, in case of operations are there, the company's going concern, the any transactions of the sale, purchase or whatever, renting all with the related party of the CD must not be entered until you get the approval of the CoC. This is very important power which is assigned, and we need to take the prior approval. Then amend constitutional document of the corporate debtor. We usually do not do that. So we need not to amend the constitutional document. Then delegate RP authority to any other person. This is the area which is much more deliberated. Even IBBI is very strict in this area because RP cannot delegate its authority to any other person. But if RP cannot delegate the authority, then how will it work? It can, but this is with the prior approval of the CoC. So regarding delegation of authority, can we discuss something? Can we share the experience how you people are doing this? Getting the approval of the CoC, delegation their authority. Then dispose of or permit disposal of the shares of the any shareholder. Change of management of the corporate debtor and its subsidiary. Change of management. So I want to share my experience here. Change of management of the corporate debtor or its subsidiary without the prior approval of the CoC. In case the company is close, the CD is close, then can we, can we ask the persons who are on the roll not to ask them that they are out, they are retrenched, or they have been removed, or they have been retired since the commencement of the CRP? What is your view on this? This is very important point for discussion. So I would request your experience, change of management or this one. Sorry, this one. Yes, sir. Any experience, any view on this point? Change management of the corporate debtor or subsidiary and other points, sir. That in case of CDs not working as a going concern, can we ask their employees who are on roll that they are not, they will not be treated as the employee and their salary shall not be formed part of the CRP cost. Can we do that? Anybody can share their experience, because this is a dicey point. Gauravji, your take on this?
No, sir.
Okay. So suppose that if the company is not in operation and there are hundreds of employees, it was a factory unit. There are hundreds of employees who were employed there, but they have not been retrenched. And suddenly the operation of the companies stop. But they are all on-roll employee. their salary will continue if you do not give them a notice. Correct? So in that case, what you can do, what you will do, that you will give them notice that there is no work, so there will be no pay. Although they have not been retrenched, but no work, no pay notice may be given, and the liability of the CD can be limited to that extent. Once the CD gets revived or the resolution plan approved, then they may continue by the SRA who is coming into the company by change of the management. But if you want to change any person, suppose there is some finance controller in the CD, and if you want to change, or then it's a management person, then you have to seek the prior approval of the CoC before effecting any such change. Then transfer right or debts under the material contract outside ordinary course of business. In this case also, you have to seek the prior approval of the CoC. Change in appointment or contract terms of personnel by specified for person as specified by the CoC. Again, CoC approval is required for this. Then change in appointment terms of the statutory or internal auditors and procedure and consequences of thereon. So these are the certain clauses under section 28. Then RP must convene a CoC meeting and seek approval before acting any above matters. Approval must be obtained by at least 75%, I think. I think it is 66%. I something.
66%.
It is 66%. This is old one, so it is changed now. Action taken without such approval shall be void, and RP has to face the consequences. Now, implications of the CoC power arms. Coming to the how the CoC decision directly influence the survival or liquidation of the corporate debtor. I shared one of the scenario where the CD was as a going concern, but CoC did not fund any amount in the CoC because in the CD, because CoC was of the view that they are not here to fund the CD, they are here for their own purposes. So we have to analyze, we have to convince the CoC member that putting the fund may have the, influence on the survival or liquidation of the corporate debtor. To maximize the assets also, we have to be very careful. So CoC power have been very carefully. Then the CoC assume control over the debtor's affair during the CRP, acting in place of suspended management and board. So one problem I faced during the CRP, that how do we conduct the shareholder meeting? Because RP has to run the CD as a going concern, he has to ensure the compliance of all the laws applicable to it. Board is suspended, power is assumed by the CoC, but we have to conduct the AGM and all. Though, how you people are doing that? Any experience in that regard? See, board meeting is gone. In place of board meeting, CoC meeting is there. But accounts adoption and all, which is required under the company yet, how that will be governed? Any view on this by any London member? No. So my experience is that we prepare the accounts. If it is possible, we place the account before the CoC meeting for their taking note of. Then, if possible, if it's a closely held company, we can ask the shareholder for the adoption. But in cases, it is not possible. It is now almost impossible to get the accounts adopted and do the compliances and all. The Commercial wisdom of the CoC in evaluating and approving the resolution plan have been given. Wide judicial differences by courts reaffirming the CoC's autonomy. This point specifically we will discuss in last. We have prepared certain slide for this judicial intervention. Then requires high accountability and informed decision making due to wide reaching impact on the. So now coming to the meeting part, na? So this
Sir,
is just
sorry to interrupt, sir. I have one query related to interim finance.
yes, please.
Sir, in one of my case, I have already raised the interim finance. And now the status of CIRP is that the resolution plan is already filed for the approval before the AA. And there are some urgent CIRP costs and RP is not able to raise further interim finance. So what we did that we put the agenda before the CoC to contribute to urgent CIRP cost like security charges and all. But that was not approved by like 66% what is required, but that was not approved. Sir, in that scenario, what can be done, sir?
See, you have the interim finance approved from the
Yeah,
CoC.
that was yes, that was approved and that was already availed earlier. But right
Okay.
now, not able to get more interim finance from outside.
Without the approval, you also cannot do that, right? And
Yes, that was approved earlier and that was utilized actually.
so there were certain amount na, which you have already availed, correct?
Yes, yes, exactly, sir.
And you want more amount to be availed.
Yeah, yes, now actually, plan application has already been filed, but there are lots of litigations in the plan application. So process is going so long. So during that period, I required more fund for the urgent CIRP cost, like for the security purpose and all, keep the city as a like intact.
Correct. So,
So in that case, I have also put the agenda before the CoC to contribute to the urgent CIRP cost at least. I have not withdrawn RP salary and all, but I have put the agenda to at least meet out the urgent CIRP cost, and that resolution was not get the requisite vote of 66%. So in that case, what I can do, sir?
So you can again see this is the problem na, which I think every RP is facing, including me also. So in your
And
case,
sir, I have seen the judgments also, unclear judgments also, wherein it was stated that it's a commercial wisdom of CoC. Because CoC has to take the decision and authority will not interfere in that.
yes, Mr. Pramod,
So we are helpless.
Yes, yes. So in such situation, madam, I suggest not to proceed ahead unless you get the approval from the CoC, because you are there to manage the CD. Ultimately, if
Yes.
you get further finance and tomorrow CoC reject this same thing, it will be your personal responsibility. So you put before them, okay, this is the urgency, and you completed your duty. You can call another 2-3 meetings also showing the urgency. But unless you get the green signal from CoC, I strongly suggest not to take any single rupee as an interim finance further.
Actually, sir, from outside, I'm not getting any finance. I'm asking from the CoC member to contribute percentage proportionate to their claim amount, and they're not ready.
Then in such situation, make the evidences 2-3 times, invite the CoC meeting, insist them to either vote in favor or reject, and after that approach to the AA that okay, this is the fact, I stuck there, what to do.
Okay, sir. Thank you, sir.
yeah, so so we cannot run away in between. No? We have to perform the things, Ms. Manisha.
Sir,
And
and one judgment I have also seen wherein this agenda was approved by more than 66%. So one dissenting shareholder was financial creditor was there. So RPS filed the application against him. In that scenario, NCLT direct him to pay the amount. Actually, the agenda was passed with the 66% vote. So in that scenario, that was accepted. In my case, the situation is different because the requisite vote is not received for that agenda item.
see, in cases where the CoC not contributing, either you bear that burden. I mean, to pursue the service provider, please wait for some more time, please wait for some time, which we all are doing.
Yes,
And
sir.
apart from that, you can, as Pramod ji suggested, that you can file the IA before the NCLT, you know, asking them to contribute. And in one case, if you remember that, you can ask the CoC that if you are not contributing to the CRP cost, I can nullify your claim.
Yeah, that order also I have got it from the,
But-
but that was NCLT order. Yeah,
But
that order also I got.
but these are not the practical solution, ma'am.
Yes,
Tell you.
exactly.
We have to work here and we have to make the balance. We again have to, I mean, pursue this UC member. So to get some fund even in part so that you could pay the mandatory payment to the security agency to get the asset protected. Otherwise, protection of the assets are at stake. So this
So
is
in this regard, I have also the same question regarding those who have abstained from the voting. What their treatment?
if they are absent from the voting, then I mean, voting is not complete.
Whether it will be treated as positive vote or negative
No,
if
see,
some are abstain.
no, see, whatever the voting is there, then you have to exclude that abstain voting percentage.
So
Got my
can we
point?
do so?
So if you can, I mean, explain in numbers, then it will be, I mean, and easy to understand what.
Sir, if 70% is there, say example, if 70% are assented to that resolution and 30% abstain from voting. So for total voting, we will consider 100% or 70% as 100%.
70% as 100%. See, abstain means they are out. They not attended the meeting, so we need not to calculate them. If 70%,
Okay.
so
Abstain means that they are not interested to vote. They
yes,
remain to neutral, but they are in the meeting.
correct.
Yes, exactly.
So your
So,
resolution.
but in one of the Supreme Court judgment, I have seen that on the voting of the resolution plan, few financial creditors were abstained. But I think in that judgment, I can't recall the name of that judgment, but in that judgment, it was decided that to consider that abstained also for the majority voting, not to exclude that from the voting criteria.
So you are not
That's why I am
excluding.
confused.
No, you are not excluding. If 70% vote is there, then it is assumed that it is passed.
No, not my question. Pramod sir, I think understand. Actually,
So
I'm
even yes, I got your point, madam. Even not
yes.
70%, say 30%, 100 are the voting. Out of that, 20% remain absent, and out
Yes.
of 80, you got the 70%. It is approved.
Yes.
Because you got that 66% threshold limit.
Exactly.
Correct. See. All right.
Thank you, sir.
Now notice that.
Sir, I have a question to you.
Yes, Mr.
Sir, can CoC have a power to recall a rational plan that is already approved and letter of intent is issued and ask the RP to reissue Form G?
With the approval of the AA, it can be done, but the current situation is this, sir. The NCLAT in many matters have held that once the CoC approved the plan, it is not open to the CoC to demand it back. So I have also some cases where CoC did the same thing which you are telling me. We have filed the application, it is still pending, and I assume that it will not go through. The plan approved, which will not be demand back. But definitely there are other situations also where in certain cases the plan may be remanded back on happening certain events. It depends on case to case. I don't know in your case what is the reason why the CoC is asking for remand back and issue of the fresh Form G after approval. If you can share the exact reason for the sake of understanding for all of us. गौरव जी क्या रीजन था उसमें? गौरव जी
सर CoC में कुछ नए मेंबर्स ऐड हुए थे
जी,
तो उनके कारण उन्होंने उसको रिकॉल करने के लिए दिया था तो वही इस चीज को कन्फर्म कर रहा था आप ना।
You are CoC and the voting percentage has changed. And the new person
Yes, sir.
and the new member, new CoC members having the greater say than the earlier, and they want the resolution plan to be demanded back. But there must be some reason now. On what reason they are asking that it should be remanded back? Value has been assigned lower to their expectation or some other matter, some other reason.
Yes, sir. The voting percentage of CoC changed.
Pramod ji, what is your view?
Sir, in such situation, as a RP, what we need to ask to the new incoming CoC member, the reason why they want to recall the call, recall the again.
Plan already approved.
If reason is justifiable,
Uh.
still as a RP, we should ask them, sir, go to the AA because already matter is initiated and it is LOI is already proceeded. So in such situation, rather than directly denying, it's better approach to the AA if valid reason is there.
Otherwise, you cannot deny the decision of this CoC. You have to now approach the A. So Gaurav ji, if your CoC is asking like this, you can ask the specific region and file the application before the A. Let the A take the call. What to do, what not to do. Correct?
Okay, sir.
All right, sir. So notice and timing, sir. So as all of you are aware that minimum 5 days advance notice must be given to all the CoC members before a meeting as per regulation 19. We send the notice through email usually, and although it is there that the notice may be sent physically, but I never send the notice in physical. If any member has sent the notice in physical form, any of the members who is attending the this workshop, have they sent any meeting of the notice physically apart from other than this email? I think nobody should have seen. Otherwise, this 5 days limit may not be complying. Then notice include the date, time, venue or mode, agenda and relevant supporting documents. So as a RP or IRP, we have to, while sending the notice under the subject line, we have to write the name of the notice, its venue, time. So all have to be very specific while sending the notice through email. And then in urgent cases, shorter notice of less than 24 hours may be allowed if CoC member consent. So although 5 days timeline is there, but in urgent cases, the RP can send the notice less than 24 hours. But in real estate matters where the AR is appointed, this timeline is 48 hours. So we have to be very punctual about it because it's a procedural matter, and IBPI usually check whether the notice has been sent in time or not. Notice must be sent with entire documents and papers, complete agenda to all the members of the CoC. So here we have to be very strict and punctual about this.
Shravanji, one point here.
Yes, sir.
When we are starting the CIRP, generally we follow this process. In first meeting itself, this shorter notice agenda we get it approved, so that in future wherever is required, we need not to wait for the longer time. This
Yes.
is good practice.
Yes, it's a good practice, sir. है ना? So even CoC usually ask us not to, approve this shorter agenda. So we usually have to pursue them. See, I will ask you before sending this shorter notice. We will take care of that. So please approve it. So in sometimes CoC do not approve this even shorter notice. But it is good practice if we get it approved in the very first meeting. Correct. one more query here, my experience that suppose we approve the shorter notice for 48 hours, right? From the CoC, and we require the notice to be sent for 24 hours as given in the regulations. Can we do that, Pramodji?
Ideally, no, because the approval is taken for 48 hours. So we need to follow that thing.
But even in that case, what I have done, so we have taken the approval for 48 hours, correct? But we send the notice in case more less than that, but more than 48 hours, 24 hours, we took the approval in the meeting itself for this shorter notice also. Correct?
If everyone is agree, then no problem. But process should be that whatever is timeline taken, we need to.
So the purpose is that you need not to take the approval in every meeting, na? If you are sending less than 5 days notice. But in a special situation, even though you have the approval of 48 hours, and if you want to send the notice for less than that, you can take the approval in the next meeting for that particular meeting.
So in first meeting itself, our wording of that agenda should be like this. Get it?
Like this. Correct. Then agenda and documentation, I explained that agenda must be clear, outline the matters to be discussed and resolution to be considered. So here IBBI also amended that in the notice or agenda itself, one has to be very clearly mention that what are the items which are required to be voted and what are the items which are required to be taken note or discussed, whatever it is. And notice must be circulated in advance to give members adequate time to review it. Then proper disclosures and clarity in documentation help to avoid disputes and ensure informed decision making. Then mode of and format of the meeting. So this earlier in the initial phase when this IBC came into picture, before particularly before the coronavirus spread over the country, this CoC meeting usually was in the physical mode, complete in the physical mode. And after that, now it is the CoC meeting is only in the virtual mode, though it's a hybrid mode, but nobody attend physically. It is only in hybrid mode. So mode and format of the meeting, CoC meeting can be held in physical, virtual or hybrid mode as per the members' convenience or as per the RP convenience. The mode must be mentioned in the notice itself and access details shared in advance before the meeting. A meeting is valid only if the required quorum is present at the start of the meeting, and if quorum is not met, the meeting can be adjourned and reconvened with proper notice on the next day at the same time and place. So this is the requirement of the meeting. Then let us come to the conduct of the meeting. Pre-meeting preparation, all have to keep in mind that finalize and circulate a clear structured agenda well in advance. Ensure information memorandum and other documents are complete and ready for discussion. If there is any specific request from the members that certain information is required, obviously you need the NDA, non-disclosure agreement, before sharing the IM. So, and if it is shared, then you can discuss certain information in the CoC meeting. Confirm availability and participation of all the CoC members to meet quorum and requirements. Test virtual platforms and e-voting system for smooth conduct of the meeting. So this is the pre-meeting preparation RP has to do. Then in meeting procedures, being by confirmation, confirming quorum, revision 22. What is the percentage of quorum? 33%. And it has to be present all over the meeting, the entire proceedings of the meeting. Present agenda item and supporting documents clearly ensuring all the members understand the context. Facilitate structured discussions and deliberations without influencing members' decision. And record any points, suggestions, and objections for the inclusion in the minutes under section 24 of the IBBI. So in cases where there are no number of CoC members, like 20, 25 members, and in the virtual meeting, you have to accommodate all the members, and every members want to speak or want to present their views. So in that case, it is very important how to conduct the meeting, how you will, I mean, ensure that every participants presented their view and the meeting is in order. So this is all the procedures you need to take care during the meeting. And post-meeting actions, draft and circulate minutes of the meeting to all the CoC members within the prescribed timeline. And what is the prescribed timeline? That is the 48 hours. And regarding the e-voting, you have to typically you open the window 24-hour post meeting as per the regulation 25. Ensure all resolutions and voting outcomes are recorded and filed and filled appropriately, and maintain proper documentation of the future references and regulatory scrutiny. So we have discussed the e-voting, voting, sending of the resolution through email. We have also discussed. So this we will not discuss. Regarding minutes. Yes, sir, Pramod.
I have one query here, sir.
Yes, sir.
If meeting is conducted virtually and minutes also circulated, after 1 month, if CoC member asks the recording and insist for the sharing the recording, whether it is binding on the RP to share the same or not?
There is no harm in sharing the recording first. Secondly, since all the CRP process, the complete CRP process is for the resolution, I assume. And CoC is the main part. You cannot deny actually. And if you deny it, the matter will go to the NCLT. NCLT will direct what is the harm? Why are you not giving them? What is the problem? What is there in that recording? So I think we must not, I mean, get into this. We are not providing you. Why? We should provide, I think.
But what is the law? Whether it is mandatory binding on the RP to provide the recording, because
Sir,
minutes.
Since the law is silent on this, that is why we are discussing. But ideally, let us understand what NCLT will do if the matter goes before them. So if the matter reaches to them, to the bench, then NCLT will simply decide, provide the recording. Why are you stopping them? So to avoid those situations, you can. And other thing, you are saying that what the law says. Law says now you have to provide the like information of the company by getting the NDA, non-disclosure agreement, confidential undertaking and all. So before providing, you can get, ठीक है मैं आपको दे रहा हूँ, I am giving you, you give me that undertaking that you will not misuse it, you have it. So we have to now make the balance. That's it. Most post meeting draft regarding the minutes now. So we circulate the minutes within 48 hours, right, sir? Then we conduct the this e-voting, and we finalize the e-voting. Then we share the e-voting result thereafter. Earlier, when there is e-voting, I usually send the minutes after incorporating e-voting result to the CoC members after 48 hours of the completion of the e-voting. So since the e-voting result is the integral part of the meeting, that practice I have discontinued. I'm just sending the minutes of the minutes first within 48 hours, then e-voting result thereafter. So it is the practice I have just said. If anybody is adopting the practice of sending the minutes, incorporating the voting result right now. Pramod ji, what are you doing? In case of e-voting, are you sending the minutes after incorporating voting result, or only sending the voting result after the minutes?
Total will send total.
Total, well, sending the voting result only. Okay.
No, sir, both minutes plus voting results.
The minutes you are sending now after 48 hours, correct? But
Yes, sir.
after getting the e-voting, are you further preparing the minutes, incorporating the voting result, or simply sending the voting result, which you have achieved or arrived after voting? That is my query. So I am doing right now. Earlier, I was used to incorporate the voting result into the minutes that I used to say. So now coming to the role of the IRP and RP. Facilitator, not a decision maker. Much area of problem. So the RP must act neutrally and cannot influence or impose decision on the CoC. We never tried that. Do we? We are only facilitator, no? We do not impose any decision or influence on the CoC member. Their role is to present facts, data, and legal interpretation without bias. Yes, we are doing that. Must ensure all CoC members have equal access to information and time to deliberate. We tried that. Cannot substitute the commercial wisdom of the CoC with personal judgment. Yes. So this commercial wisdom is very debatable issue nowadays. Under the commercial wisdom garb, the CoC members do whatever they want to do. So we need the code of conduct for CoC. Although the IBBI has come out in the August 2024 some guidelines, but I don't know whether they are following or not in other matters. Pramodji, what is your experience in that regard? What problem you are facing with, or are you able to, happily conclude your CoC meetings? All the resolutions which you have placed are happily compiled, or it is deferred or not? Just like Manisha is saying that they are not approving the expenses. In most of the cases, they do not approve the expenses. They used to defer the agenda item. कि ठीक है इसको अगली मीटिंग में रखते हैं. तो ये these are the problems we professionals are facing here. I don't know all are facing or not. So is it same, or you have this different opinion experience?
5 fingers are same everywhere, sir.
Correct. True, sir. So cannot. Then, sir, neutral communication and record keeping. The RP must communicate facts objectively without influencing CoC decision. Must maintain equal access to information to all the members CoC. No preferential disclosure. Avoid giving personal opinion or advice that could seen as a bias to the CoC commercial wisdom. Ensure complete, clear, and timely documentation to all the communications, notices, and decisions. Keep records of the claim minutes and all. So, as per the IBBI regulation. After the meeting, then regulatory compliances by the RP. This do we need to discuss this? I think let us skip now. Ensure all the compliances now. This we are doing. Voting process. Voting process we also dealt with, but again, regulation 25 requires e-voting to be initiated after the CoC meeting concludes, generally within 24 hours, conducted by secure encrypted electronic platform approved by the RP. Pramodji, this is the clause which I was suggesting that we must do the e-voting, not sending the resolution for approval through email, because email may not be in a secure encrypted electronic platform. But we should, try to get the things done through e-voting only. Then voting window must remain open for at least 24 hours and should not exceed 7 days, ensuring equal opportunity to all the members. Here, sir, we all are facing problems. What we are doing in case there is a holiday? Any experience, any good practice one can suggest in case of holiday, because now banks do not work on holiday. If it's a 4 or second Saturday, the banks are closed, and on Sunday. And suppose the 7 days timeline is going to over, and we have to extend the voting line that cannot extend beyond 24 hours. So what to do in that case?
So we generally exclude that.
Okay, you exclude the holiday, right?
Yes, sir. Yes.
Other member, other participant, what are they doing? Are they excluding, or they are still increasing 24 by 24 na? In one go only 24 hours? We may exclude, although that is not written in the regulation, but considering the practice, we may exclude, but don't know how the IPBI will treat that. To on a very safer side, we can extend on 24 hours basis only, because regulation says it is only 24 hours. Then the RP shall not extend the voting window where the matter listed for voting have already received majority votes and one extension has been given. So here we have to take caution that if the particular item is decided, and after that only one extension can be given, and after that we have to close that resolution for decision. Then voting rights are proportionate to the creditors voting share calculated on the admitted date. Okay, we all understood this. Each resolution is voted separately. Result must be recorded and communicated promptly within 24 hours of the conclusion of the voting. RP ensures confidentiality and scrutiny and security of the voting process. In case tie or insufficient votes, resolution is deemed rejected. Results are filed with NCLT and shared with all the CoC members. Technical and legal aspect, there are certain things I have compiled here. Must use a secure and reliable e-voting platform with access controls and audit logs. Usually all the voting platforms have this feature. The RP is responsible for setting up the voting system and verifying member identities. RP has to work as a scrutinizer. So RP is doing all these activities. Voting links must be unique, confidential, and time-bound to avoid tampering or multiple submissions. So once the vote is submitted, it is not open to submit it again, because it gets closed, window gets closed. Then at the end of the voting period, the voting portal shall forthwith be blocked. It is blocked. Legal validity stems from Declaration 25 of the IPBI CRP regulations. So this. Then lack of timely participation from some creditors caused during the voting result. This we all face or we experience. Ambiguity in claim amounts leads to confusion in assigning voting shares. So these are the challenges in the CoC voting. Disputes over whether creditors is related party or eligible to vote or not. So here we handle the situation very diplomatically and in a very amicable manner. Technical glitches in e-voting platforms may hinder access or submissions. So to overcome this, we usually provide the mobile number and phone numbers to the CoC members, that in case you face any problem, you are not able to vote, then you can directly call to the service provider and he will assist. So nowadays these problems are not happening. Earlier in the earlier times, so the login and all problems was there. So it's not happening right now. So some members abstain deliberately to block or stall resolutions. So this is the tactic. So we will not go into this. The challenges in the CoC meeting, common disputes. So we already have discussed much more, but again, we have jotted down the points so we can see it. Disagreements over the claim admission and voting rights of the creditors. So we have to get them understand what is the process, why the particular claim has been submitted, admitted, and what are the voting rights and all. So we have to be very knowledgeable. We have to understand the law, and so that the people, the CoC members, can get it understand. Then conflict regarding related party status and exclusion from the voting. So now related party persons are also knowing that they do not have any voting rights, so they have been excluded from the voting. Then challenges to the eligibility of the resolution applicant under section 29A. Sir, this is the most crucial section under in the entire IBC, because 29 is a very wide section, and this is a challenging task for the CoC as well as the RP, because in some cases RP find that the particular RA is not eligible under section 29A, but CoCs find that, and CoC consider them as a eligible person, and there is dispute. So these are the common disputes which are there. Number of case laws are there. We will also discuss some in brief here. Then disputes on valuation reports and distribution of the proceeds. So here I want to open this platform for discussion on the valuation reports and distribution of the proceeds, which anyone has, face or have the experience before the CoC regarding the valuation. Pramod ji, regarding valuation, your views or your experience you can share, please, if you are there. In most of the cases, the valuation, we have to appoint the valuer under each class. At least 2 valuers we have to appoint. One is plant machinery, second is the land building, and third is the security and financial assets. So where we appoint the valuers and they value the particular assets, and we share the valuation to the CoC member. CoC member usually, do not satisfied. They say that they are not convinced with the valuation done by the valuers. That is why the IBBI has come out with some amendments that the methodology to be discussed by the valuer before the CoC meeting. So the valuer are invited before the CoC meeting to discuss the methodology they have adopted while valuing the particular assets. Then valuation reports and distribution proceeds. This is all. Then conflict of the interest among the CoC members influencing decision. So this conflict of the interest among CoC members, this is also a very much area of debate, because suppose in cases where some financial creditors having certain assets as mortgage with them, and other financial creditors having certain assets as mortgage with them, and the value of both the mortgage assets with different financial creditors are differ substantially. In that case, under the resolution plan, the member of the CoC having the substantial assets mortgage in their favor, they want the preferential treatment, or they want the higher amount under the resolution plan. So this is again a area of conflict of interest among the CoC members, which influence the decisions of the CoC. The RP has to explain the entire regulations, rules, practices, judicial pronouncement to the CoC members, and accordingly, this conflict may be resolved. So these are the some common area of disputes, and allegations of bias and non-bias neutrality may be imposed against the RP. So RP has to take care again here. Then conflict, what are the conflict? Appointment versus approval of the professional by the CoC. So this is the one of the area that appointment of the professional is an RP function, while approval of the cost fee is CoC rule. So usually some of the IPs place the resolution for appointment of the professional and they seek the approval from the CoC. But the approval part is only for the fee or the cost. It is the appointment is the domain of the RP. So here we must not confuse, or we must be very clear that appointment is the role of the RP. So in IBBI circular dated October 2018, the RP may appoint the profession required to conduct the CRP. However, the fee and expenses must be ratified by the CoC to be considered as the part of the CRP cost. CoC does not approve the appointment but approves the cost. So this we have to bear in mind. Again, the problem is this, CoC do not understand. They do not actually fund the amount. Manisha ji also facing the problem. We all are facing the problem. So this, there must be some regulations. There must be some code of conduct, which IBBI is talking about to for the CoC members also, so that the proper resolutions and the CoC meeting may have a good impact on the entire CRP process. So operational hurdles, difficulty coordinating schedules of diverse financial caterers. This is the problem. Technical issues in virtual meeting, language and documentation gaps in stakeholders environment, delay in circulation of the agenda information memorandum, inadequate time for reviewing documents or plans before the meeting. So these are the operational hurdles. This can be taken care of. Then legal gray area, ambiguity in definition of the related party. So although by the passage of the time and judicial pronouncement, this ambiguity has been settling. Unclear threshold for CoC formation when claims are under verification. So this is also a gray area when the claims are kept under verifications and they are not assigned the votings here. The RP has to be careful here while constituting the committee of creditors, and as soon as possible, the claim must be verified. Then disputes over classification of the debts, operational versus financial or quasi-debt. So, because this has the bearing on the constitution of the CoC and the voting power. Then lack of the clarity on the CoC role in plan implementation post-approval. So, this is the legal gray area. And let us best practices. We have discussed many things here. We can adopt the best practices based on our experience and problems. There are much material available here. The case laws are there. Then we can adopt the best practices. And pre-meeting best practices we have already done. Meeting tips start with quorum confirmation and brief recap of the previous meeting's outcome to aware the members of the CoC what is going in the CRP. Then follow the agenda strictly and sequentially to ensure focused discussion in the meeting. Keep discussion time bound and discourage repetition of off-topic points, because if you know in certain meetings we generally stuck in one or other point, and we discuss unnecessarily large amounts. So if the situation arises, RP must take the decision appropriately and ensure the RP remain neutral and procedural. It is not encourage participants from all the creditors, including minority stakeholders, to participate in the meeting. So this is post-meeting diligence we have already discussed. We will not go it again. Relevant case law. So in point-wise we can discuss, because these are the very landmark judgment. SR Steel versus Satish Kumar Gupta and others, 2019. This is the landmark judgment which was quoted in this CRP process most of the time. And in this judgment, the commercial wisdom of the CoC was pronounced to be supreme. So the SR steel matter was there. Total debt of 54,000 crore, and the major stakeholder, major FCs were SBI, ICI, and PNB. So we have write down the ArcelorMittal and Nimtel were the key resolution applicants. CoC was voted in favor of the ArcelorMittal plan of 42,000 crore. Then NCLT approved the plan, but OC challenged the unequal treatment in this case. Just for a recap, I am reading this point. NCLAT modified the CoC approved plan and mandating equal treatment to FC and OC. CoC appealed Supreme Court, citing infringement of the commercial wisdom. Then Supreme Court ruled out that and uphold that primacy of the CoC commercial wisdom. And it was also held that the NCLT and NCLT cannot interfere with distribution mechanism under the approved plan. Classified that equality among creditors, that is equal payment, and emphasized adherence of section 30 subsection 2 fair treatment to the operational creditors. And the key takeaways of the insolvency for the insolvency professionals in this segment was distribution of the distribution as per waterfall mechanism is the CoC domain, and courts cannot interfere it. It can only review. CoC must document fair treatment and rationale about different payouts while discussing the resolution plan. Then importance of a well-reasoned resolution plan and expert evaluation, that all discussed. So another case which was there, A&G industry, that I will not discuss here. I will skip it. Now the recent judgment which has announced in Bhushan Power and Steel Limited. So this is the first judgment after this SR, which question mark the commercial wisdom of the CoC. So the background of this case is that the CRP was initiated in 2017, and JSW Steel's 19,700 crore resolution plan was approved by the CoC and NCLAT with certain modifications. Plan included upfront payment to financial creditors and equity infusion approved in 2019 by the CoC and NCLT. Then Supreme Court finding on 2nd May 2025, the Supreme Court upheld that the resolution plan was not compliant with the IBC CRP regulations. Procedural and legal deficiencies was there. RP failed to discharge statutory duties properly during the CIRP. Why I am discussing this? Because under this, in the CoC meeting, all the discussions have take place. And this is a very alarming judgment which question mark the commercial wisdom of the CoC, and it defined what is commercial wisdom and what is not. The Supreme Court also said that CoC abused its commercial wisdom and approving a flawed plan and accepting payments prematurely. The plan was declared illegal and sent back, and CoC and RP and NCLT actions were criticized in this judgment. Although it is under review, and the liquidation which was ordered has been paused for now. So this is very important judgment, and I recommend every participants or every IP must go through this judgment. And subsequent development, this on May 26th, the Supreme Court issued a status quo, pausing liquidation pending JSW review petition. And this is why Supreme Court judgment in this matter is held landmark, because judicial override of CoC commercial wisdom, which was earlier not there, and since SR Steel and case either case. Now, if in these two matters, primacy of the commercial wisdom was upheld, and second, invalidated a concluded resolution plan post approval. So this is again why this judgment is landmark, because in none of the matters the already approved resolution plan was cancelled, but in this matter the plan was cancelled and the CD was sent into the liquidation. So Supreme Court ordered liquidation prior to this. So key takeaways of this judgment: rigorous regulatory and procedural compliance is non-negotiable. We all have to follow the procedural and regulatory framework in letter and spirit. CoC's commercial wisdom is not a shield against procedural lapses. So we have to see whether there is any procedural lapses. If it is there, we must warn, must alarm. Then RP's accountability is critical. Failure can invalidate the entire resolution. Courts may order liquidation despite plan approval is if process is flawed. Then post-judgment review petition is stays can impact execution. CoC must stay based. And legal and procedure guidelines, I am skipping this. Any point we can discuss as a question or as your opinion? But although it is very interactive workshop, can we discuss anything?
सर
Yes, sir.
सर प्रोसेसेस में सीआरपी कॉस्ट में आरपी की फीस पे नहीं हो पाती है सर नॉर्मली.
Yes, sir.
वो क्या प्रोसीजर रहता है सर, उसको मतलब मिल जाए और
आरपी की फीस पे नहीं हो पाती है ना गौरव जी? आप ये कह रहे हो ना, आरपी की फीस पे नहीं हो पाती है प्रोसेस में?
हाँ जी सर.
सर देखिए, the fees to be paid by the CoC members, correct? And if possible, we can approve the interim finance and get it. Otherwise, we all are suffering, sir. Na? So we need to request the IBBI and our IPA to frame the guidelines, certain guidelines, although certain guidelines were issued by the IBBI, but it has to be followed by the banks, financial institutions. They mandatorily has to, fund the CRP cost month on month basis. Because if the funds are giving it in time, more efficiency could be brought into this CRP process. Although I am not saying that the efficiency is not there, but since we are following for the getting the funds and make the payment to the service provider, the process some or other how the focus diverted. So this is the things only where we can get the our fee or the CRP cost. So when we say our fees, we should say as the CRP cost, not insisting on our fees. We should ask the CRP cost. Any other thing? Otherwise, let us wind up this session. Yes, Mr. Pramod.
Sir, I think main problem comes where the CoC consists of the OCs. At that time, we face the problem of getting the fees. But where FCs are there, generally fees is paid by them, subject to from day one we need to educate them that see, as a RP we are also providing the services, and once they are happy with our work, then definitely I don't think there is any reason for not paying the fees to the RP. From the FC side, OC, yes, I face the problem from the OC, not got fees many times. This is
Correct. No, you are right, but there are certain problems now. So it is day by day, settling, because CoC members understand that yes, we are performing and we need the fund. But the problem is this: the higher authorities where they have to put up now for reimbursement and all. That time, mostly time is taken there. Otherwise, COC members are they can understand regarding the fees is there. But they every time they are concerned with our fees. They want to discuss on that part, but they have to discuss on the other part also. Na? The problem this is there. Na? So gradually they will educate. But if COC guidelines is there, code of conduct may be framed by the IBBI, then this will be a great help to all of us. So, any other question? Otherwise, I would request ICSI IIP to conclude this session.
Or one practical answer I want to share here.
Yes, sir. Yes, sir.
That I was appointed in one case
Hmm.
where COC was sole OCs, means two OCs were there only.
Okay.
And again, after that, income tax and GST come into picture.
Ha.
So we treated them as a OC, but as there was no FC, we asked them. So GST strictly told that, sir, we are a government officer. We just understand to getting in. We cannot pay any single rupee. So
Correct.
GST out.
Correct.
Now, the person who initiated the matter,
Ha.
they initiated for the purpose of recovery.
Ha. Ha.
Their counsel who suggested them, he was not aware of the facts. And almost near about 7-8 months, we provided service as a IRP, RP to them. And at that time, we felt that we should not lose our fees in such situation because already we work for them. So we requested to the OCs, they denied to take the call, everything. Then we filed the IA before the Honorable NCLT. After near about 18 hearing, NCLT took this, okay, genuine things are there. Then we make the newspaper publication first, intimation, then court notice, then newspaper publication, and now till today they are not appeared. So NCLT agreed to provide the warrant.
Okay, great.
That is phase is going on. So these things are happen with the RPs many times. But
Yes, yes.
we pursue for our peace.
Yes, sir. These are happening. है ना? These are happening. Correct, sir. So the hidden motive of this code is to recovery, but it is not written there. So everybody is working for their recovery only, whether it's OC or FC. Anjali ji, are you there? On
Yes, sir.
ICS? Yeah, Anjali ji, we can conclude this session now.
Okay, thank you very much, sir, for sharing your valuable time and making the session so much of interactive. Sir, you are requested to share a presentation with us.
Yes, yes, sir. Thank you, Anjali ji, and thank you all the participants for lovely discussions and sharing your experience. I really enjoyed this session. Thank you so much. I'm sharing Anjali
Thank
ji.
you, sir. Thank you,
Yes,
sir.
thank you.
Now there is lunch break till 2 p.m. Next session will be at 2. Shall we start, sir? Rajendran, sir, shall we start? Rajendra, shall we start?
Am I audible?
Good afternoon, sir. Shall we start now?
Yes, we can start. Am I audible?
Yes, sir. One second, sir. Good
Okay.
afternoon, everyone. I welcome you all to the next session of the workshop on the topic balancing the interest of stakeholders under IBC. Today we have with us Rajinder, sir. Sir is CS, cost accountant at IP. He is having over 25 years of experience in accounting, finance, taxation, corporate legal affairs, insolvency, restructuring, and valuation matters. He is also having experience in managing complex insolvency proceedings under IBC, leading corporate restructuring, liquidation, and resolution plans. He has managed multiple insolvency and restructuring assignments across banking, manufacturing, and service sectors. He has represented matters before NCLT and cleared, handled legal documentation and coordinated with CoC, creditors, and valuers, implemented corporate governance frameworks and risk mitigation strategies aligned with regulatory reforms. So now you can start with the session.
Good afternoon, everyone. It's my privilege to address you today on a topic that lies at the very core of the IBC code, balancing the interest of stakeholders. The IBC was enacted with a bold and transformative vision to provide a time-bound, transparent, and efficient mechanism for the resolution of or liquidation of financial distressed companies. But beyond process and procedure, the fundamental objective of this code is to maximize the value of assets and ensure fair and equitable treatment to all stakeholders, a task that is both complex and nuanced. Every insolvency or liquidation case brings with a diverse and at times conflicting area of stakeholders, financial guiders, sometimes operational guiders, employees, shareholders, government authorities, and potential resolution applicants. Each has legitimate expectations, legal rights, economic interests that must be considered and balanced within the framework of this code. The balancing of interests is not a merely philosophical, it is embedded in the structure of the IBC itself. Through this CoC, the code empowers financial guiders to lead decision making. CoC can take a decision while also requiring them to consider the interest of all the stakeholders, especially operational guiders. Through section 32, it mandates that operational guider receives at least the amount they would have in liquidation. Through section 53, it establishes a structured and legal binding priority for the distribution of proceeds during liquidation. And though in existence of on time-bound process, the court seeks to prevent value erosion and prolonged uncertainty that harm all the stakeholders. As an insolvency professional, we are the facilitator of the delicate balance. Our responsibility is not to only manage the resolution or liquidation process in accordance with law, but to ensure that the process is fair, transparent, and respect the rights and interests of every stakeholders involved. Balancing, actually, we work as a facilitator. Decisions are taken by CoC, but we should be fair, and we have to maintain the balance of the interest of the stakeholders. Balancing these interests in practice requires accurate and impartial valuation of assets to inform recovery expectations, transparent and inclusive communication with all class of creditors, ethical conduct and procedural compliance at every stage, and where necessary, the ability to interrupt the apply legal provisions in a manner that further the court's objective of value maximization and equitable treatment. Over the past few years, we have seen a rich body of jurisprudence evolve through the NCLT, NCLAT, and the Honorable Supreme Court. These decisions continue to refine our understanding of how stakeholders' interests are to be balanced, whether in evaluating competing resolution plans, interpreting commercial wisdom, or protecting dissenting creditors. Okay, today's session is designed to explore how the IBC provides a statutory and regulatory framework for stakeholders balancing the role, right, and expectation of different stakeholders during CIRP and liquidation, the evolving jurisprudence shaping stakeholders protection, practical challenges, strategies for professionals to manage stakeholders dynamics effectively, and how we as an insolvency professional can act not just a process manager, but as the guardians of stakeholders equity. I have prepared a PPT to guide our discussion. Our goal is to build a comprehensive understanding how to uphold this spirit and structure of the IBC by ensuring a resolution process that is not a legally compliant, but just inclusive and value driven. Let's now begin our session topic, balancing the interests of the stakeholders under the IBC code. I hope PPT is visible to everyone. Am I audible now? I'm not getting any response. I'm not sure whether
Yes,
I'm
sir. Yes, sir.
okay. 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 Now we will start with the preamble. But to actually first we will understand what is the meaning of the balance interest of the stakeholders under IBC. What is the significance? What are the limitations? What is the importance? Okay. And insolvency professional as a facilitator and CoC as a decision making authority, and what is the role of the adjudicating authority. Then we will discuss the landmark judgments to better understand in case of any any issue concerns raised pertaining to the interest of the stakeholders, how we resolve, we will understand with the help of the judgments. Okay, now we will start. Remember, the IBC is a landmark reform in the Indian legal framework that aims to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals. It was enacted with the objective of promoting entrepreneurship, availability of credit, and balancing the interest of all the stakeholders. Okay. In the preamble itself, it's mentioned. Okay, and balancing the interest of all the stakeholders, including operational creditors, financial creditors, and employees, shareholders, and the corporate debtor. Okay. Means when any company is under CRP and liquidation, IRP is appointed, then IRP is appointed, then liquidator is appointed in case of liquidation. Then all the decisions are taken by the CoC. And insolvency professional works as a facilitator. Okay. But insolvency professional is also responsible to ensure that to ensure the balance interest of all the stakeholders. but ultimately CoC is responsible for, because mainly CoC take the decision. Okay, and while taking decision, they need to ensure ki whether everything is okay, and means all these stakeholders' interest is taken care. So these are the things must be taken care by the CoC as under the law. One of the foundation principle of IBC is to ensure a fair and equitable resolution process. Okay, see, that maximize the value of assets while respecting the rights and expectation of various stakeholders. The courts establish a time-bound process. Okay. And gives priority to commercial wisdom of the CoC. As you know, all the commercial decisions are taken by the CoC in decision making, and these decisions are okay as per the means under IBC code. So then, normally, adjudicating authority don't interfere. Okay, unless until it's the violation of the any under any means any provision of the IBC code. However, the balancing of interest remains a complex and evolving aspects of the code. The dynamic interplay between creditors' recovery right, debtors' revival prospects, employee welfare, government dues, and public interest necessities are nuanced and principal approach to value approach to insolvency solution. As you know, there are so many parties involved in means when any company is going to CRP, operation caterer will be there, employees will be there, and operational caterer will also submit their claims, and government dues are also means will be paid as per the waterfall mechanism under IBC code, and government will also submit their claims. Okay, and other means if means all these parties are involved and related with the process of the CRP and liquidation. So when all other parties are related, so then CoC will take decision and to maintain and to ensure the balance of the stakeholders' interest. Now, the presentation paper delivers into the legal, judiciary, and practical dimensions of stakeholders' balance under IBC. It aims to highlight how courts, regulators, and market participants interpret and implement the provision of the code to create a resolution ecosystem that is both efficient and equitable. Okay, means code also emphasizes to create a resolution ecosystem that is both efficient and equitable and also in a time-bound manner. Okay, so it means impermeable itself also means focus to ensure the balance of the balancing the interest of the stakeholders. Okay, now coming to the introduction, IBC represents a paradigm shift in the Indian legal and financial landscape, enacted with the objective of consolidating and amending the existing framework relating to IBC. The code seeks to provide a comprehensive, time-bound, and market-driven mechanism for resolution of insolvency corporate entities, partnership, and individuals. One of the key features that distinguishes the IBC from earlier legislation is emphasis on the balancing interest of the stakeholders. Okay, so that is very important factor involved in the IBC code, involved in the insolvency resolution process, unlikely earlier regimes that were largely creditors driven or debtors friendly. Okay, but IBC creates a structured process where diverse interests, those of financial creditors, operational creditors, employees, governments, authorities, shareholders, resolution applicants, and the corporate debtor must be considered and reconciled with the framework of the law. Okay, earlier laws before IBC code morally focused on the creditors or debtors means favoring, but IBC code ensure means all the parties interest means need to balance. So the IBC code emphasis on this means on this topic. Now introduction. Who are the parties? The stakeholder in Insolvency proceedings include financial creditor, primarily banks and financial institutes who have lent funds, operational creditor, vendor, suppliers, service providers, statutory authorities such as for taxes, employee and workmen's individuals whose livelihoods depends on continued operations, shareholders and promoters, owners and management of the corporate debtor, resolution applicants, entities interested in taking over and reviving the insolvent entity, government and regulatory authorities, consumer and public at large, indirect stakeholder in case where a public interest or essential services are involved. So the code emphasizes the maximization of value of assets of the corporate debtor, ensuring that the interests of the stakeholders are weighted fairly during the resolution process. It introduced the concept of the CoC, mainly comprising financial creditors as the decision-making body. However, this has raised debates around whether operational creditor and other stakeholders are adequate consideration in this process or not. Okay, means when financial creditors are only can take decision during CRP. Okay, so when CoC is taking any decision, so they will also need to ensure means the balance of the other stakeholders. They means the other party is operational creditor. Okay, they are also submitting their claims. Okay, so they will have to ensure maximization of the value of the entity so that maximum amount of the claims can be paid to the all the related stakeholders. Okay. The judiciary, particularly the NCLAT and the Supreme Court, has played a vital role in interpreting the code to ensure equitable treatment. Okay. Means there must be equitable treatment. It should not happen that only financial creditor is taking decision. It should not happen that they will not take care of the operational creditor and other stakeholders. Means if there is a government due, so there must be a equitable treatment. Okay. If only one party is in means power, for example, we can also understand. I'm just giving you the example. If only BJP is in the power, okay, so when BJP is taking any decision and implementing and making any law, so they will ensure the interest of the public. Okay, so they will ensure there must be equitable means right. So in the same manner, when financial guiders are the authority who can take only wisdom decision related to the business, so then they will also ensure the operational guider means must be taken care of fair treatment and also other stakeholders. Notable judgments have clarified the scope of fair and equitable treatment, the role of commercial wisdom, and the treatment of government dues. Okay, minority creditors and the dissenting stakeholders. While the IBC has led to increased discipline in the credit market, its implementation has also revealed certain challenges. These include delay in resolution, unequal treatment of certain class of creditors. Okay, but how can we give unequal treatment? For example, if creditors are means right to know anything, so then we need to know. Then we need to inform. For example, if creditors are submitting their claim, so we need to means if we are accepting that claim, if we are rejecting that claim, they must be know within time frame. Why whether claim is accepted or not accepted. Okay, so these things also need to ensure. Okay, but these things are taken care by the insolvency professional. But as a whole, so if any commercial decision is taken by means financial creditor, so they will see means they will not against the interest of the operational creditor. Okay, so they will also give the equal treatment to the operational creditors also. But that it doesn't mean that the equal treatment means they will also be the part of the means decision making authority in CoC. It doesn't mean. These include delay in resolution, unequal treatment of certain class of creditors, lack of effective participation of operational characters in CoC. Okay, because this happens because operational characters are means lack of effective participation. So that in majority there are means financial character is there. So that's why they can take decision accordingly. Lack of effective participation of personal characters in CoC decisions, and this need to align resolution outcomes with the broader public interest. The paper presentation seeks to explore how the IBC and its supporting jurisprudence attempt to balance conflicting interests, analyze its success in doing so, and discuss areas where further reforms of recalibrations may be necessary to uphold the objective of the justice, equity, and economic revival. Now, that was the introduction. Now coming to the definition as per the IBC code. Okay. The IBC code is a comprehensive legislation enacted by the Indian Parliament to consolidate and amend the laws relating to the revision and insolvency resolution process of corporate persons, partnership firms, and individuals in a time-bound manner. The primary objective of this code is maximization of the value of the asset of the corporate debtor. That is the prime objective of this code. Promotion of entrepreneurship, because IBC code objective is not to close the business. IBC code says if possible, so then company must, we should do such type of activities, then company can be revived. Okay, so that's why IRP and RP is appointed. In case if this thing not happen, so then company has to go to the liquidation. Availability of credit and balancing the interest of the stakeholders. Okay, so in the definition itself says, and also focus and primary objective is also to ensure balance the interest of the stakeholders, and that is very critical and important from the IBC code point of view. Okay, maximization of the value, number first. Okay, also need to ensure the balancing the interest of the stakeholders. So it means in this process, on this objective is also focused by the CoC, insolvency professional, and also adjudicating authority. And also along with these objectives, most means critical and important is ensuring timely resolution of insolvency process. As you know, this is a time-bound process. In earlier act, there was not a time-bound manner. Okay, now this act defines PRP will be in time-bound manner, liquidation will be in time-bound manner. Everything will be in a time-bound manner. So that is the beauty of this code. Okay. So now by the definition itself, we can understand this also gives more focus on balancing the interest of the stakeholders along with the maximization of the value and also along with the timely resolution of the insolvency cases. Now, who as per IBC code, who are the stakeholders? As we have also discussed above, financial character, operational character, employees and workmen, shareholders and promoters, resolution applicants who will submit their resolution plan, the third parties, they will also be the stakeholder. Okay, government and statutory bodies, consumer and public. So these are the parties are the stakeholders under the IBC code, because they are also directly or directly or somehow indirectly linked with the process of CRP and liquidation. The term stakeholders under the IBC refers to all individual entities or institutions who have a direct or indirect interest in the insolvency resolution process of a corporate debtor. This includes these parties. Okay, with directly or indirectly interest in the insolvency resolution process. So these are the parties are called stakeholders as under IBC code. Now, as per IBC code, what do we understand with the help of definition? What is the exact meaning of the balancing of interest? Balancing of stakeholder interest refer to ensuring equitable and fair treatment of all the parties involved in the insolvency process. This doesn't mean equal distribution, but rather than proportionate and justified considerations based on the nature and quantum of claims, the priority established under the IBC code, the commercial viability of the resolution plan, the sustainability of the revived entity, legal and contractual right of each class of stakeholders. Okay, so means these are the areas which are covered under the balancing of interest. Balancing of interest stakeholders means to ensure equitable and fair treatment whosoever party is related in the process of CRP or liquidation. Okay, and so in this equitable distribution, but rather proportionate and justified considerations. What is the nature and what are the quantum of claims? So these are the things taken care for the purpose of the balancing of interest. So legal basis, the preamble of IBC itself mentions to consolidate and amend the laws relating to recognition and insolvency resolution of corporate person in a time-bound manner for maximization of valuation of such assets, persons to promoting entrepreneurship, availability of the credit and balance of the interest of the stakeholders. Okay, so means its preamble itself says the primary objective is also balance the interest of the stakeholders. For section 32 of the IBC and judicial decisions, in the landmark case of Swiss Ribbons Private Limited versus Union Bank of India, reinforced that a resolution plan must balance the interest of the stakeholders to be approved. Okay. Means that means in the landmark case in the judgment, okay, it was also mentioned resolution plan must balance the interest of the whatever resolution plan is submitted and approved by the CoC. So CoC will see that this resolution plans is balance the interest of the stakeholders. Okay, this thing will also taken care while means considering or approving any resolution plan by CoC. Okay, what is the significance? Just a moment. Okay, now what is the significance? After significance, we will also see what are the limitations, what are the importance. Okay, so then we will means in summary point of view, we will discuss one short article. So then we will discuss the landmark judgments. What is the significance? The concept of the balancing the interests of the stakeholders. And also we will also understand what is the role of the insolvency professional. Okay, in view of balancing the interests of the stakeholders, and also what is the role of CoC and how do they ensure the balancing the interests of the stakeholders. We will cover all these things also in further slides. Now, the concept of balancing the interests of stakeholders under the IBC holds critical significance in ensuring that the insolvency resolution process is equitable, transparent, and sustainable. Given the multiplicity of stakeholders involved, there are multiplicity. There are so many parties involved in this, each with the distinct role, rights, and expectations. Okay, operational. What are the roles and rights? For example, financial creditor want to get it back their loan amount. Okay, that's why they are interested to means maximize the value of the assets. Okay, that's why they CoC take wisdom decisions related to the business. And what are the if there is another party is operational character, if operational character is to take money, means for example, if there is a supplier who supplied the goods and given the services to the render the services to the organization, they also expect they need the money back. They need the money. Okay, they also expect the settlement of their claims. Okay, so they expect ki if they have given supplied the material and give render the services. So in lieu of this thing, they also expect their money. Okay. So in that's why they have to submit their claims. So they also expect the full claim. Okay, so if in case company that is value is maximum, so if for example if their claim value is 500 crore and maximum value is 400 crore, so then proportionately claim will be settled. So but every stakeholder expects, for example, in case of government, dues are there, their income tax is pending or GST is pending. So their department also means expect recovery of their dues. So means every party who are the stakeholders, they expect as per their means as per their distinct roles, rights, and they expect accordingly. The success of this code relies heavily on how fairly their interests are addressed and harmonized during insolvency proceedings. Okay. Now, promotes fairness and equity. The IBC recognizes that different class of stakeholders contribute differently to the business ecosystem. Financial creditors provide capital. Operational character ensures continuity of operations, and employee run the business. Balancing interests ensure equitable, not necessary equal treatment. Okay. Balancing interests ensures equitable, means they also means given the equal importance. Okay. They are not saying means not necessarily equally treatment. Okay. For example, there is a waterfall mechanism. Okay, so then there is a priority. First we will give payment to this. Then there is a order, ranking order. So means this statement applies here. Equitable means balancing interest ensure equitable, not equal, not necessarily equal treatment. Okay. Thus preventing discrimination against the smaller or unsecured creditors and preserving faith in the insolvency mechanism. So that is very important, and maybe for the purpose of balancing the interest of the stakeholders. Ensure maximization of value. As you know, the first objective of this IBC code is to ensure maximization of the value of the organization. The balancing interest encourages collective actions and promotes value maximization of the corporate debtors' assets. When all stakeholders are given due consideration, the resolution plan is more likely to be comprehensive, sustainable, and viable, improving chance of successful revival of the corporate debtors. This is very true. In case if CoC or registered professional is able and ensure maximization of value. For example, our claim is pending or the loan amount is total everything when we are adding up the total including loan and claim total is coming 500 crore. Okay, when we are ensuring maximization of the value, if the total value is coming more than 500 crore or 500 crore, so then what will happen? The survival is revival of the operation is means possible. For example, if total is coming 500 crore due and we are only able to means get 200 crore, so then survival is practically not possible. So that's why first primary objective of the IBC code is to ensure maximization of profit, maximization of value, okay, along with the balancing of the interests of the stakeholders, along with the time bound manner, as per the IBC code. Now, enhance creditors' confidence. what will happen if promoters will fair and and also use the equity concept. So then possible ensure maximization value of the organization. So then these all these things will also create confidence in the character, whether that is operational character, whether that is the financial character. Because all the financial characters also cannot be the part of the CoC. Major 18 financial character will be part of the CoC. So that means whosoever is the character will have or will be able to, I mean, will get the more confidence. Okay. If promoters are doing fair, means during fair and equitable with all the stakeholders. Okay. The IBC credibility hinges on its ability to protect characters' right by ensuring a transparent process that respects the interests of the both financial and operational character. The court builds the investors' confidence and strengthens the credit making lenders more willing to finance business. Okay, when character have more confidence, okay, key company can survive. Okay, when they have more confidence, they can also means lend more money or can also finance. Okay, so that for the purpose of revival of the organization. Okay, if they don't have the confidence, so that they will definitely want to get their money back. Okay, in that case, what will happen? The survival will not be possible. Okay, reduction, litigation, and delays. Okay, if everything is going perfect in the right direction, okay, CoC is taking care, balancing the interest of the stakeholders, and due to this, creditors' confidence is boosting up. So then, what will happen? Okay, maybe due to this, it also helps reduce litigation and delays. When stakeholder perceive the process is fair, there is a less resistance, fewer legal disputes, and faster resolution. Judicial presence is our cities Swiss ribbons have emphasizes that the equitable treatment and adherence to the statutory priorities help in reducing the number of appeals and writs filed during or after the resolution process. Okay, so that also helps to reduce the litigation and delays. Okay, because IBC is also a time bound means manner. So if there will be more litigation, it may also impact the delay in the resolution process. Supports economic stability and employment. Balancing stakeholders interest helps in reviving viable business, preserving jobs, maintaining supply chains, and protecting customers' interests. This contributes to the larger goal of economic growth, financial discipline, and employment protection. Okay. Definitely, when company is in the mode of the survival, so then what will happen? Operational character will get their payment in time. Okay. And also, just hold on. Okay. And also, they will also be able to protect the customer's interest. Okay. And employees and worker will be also be able to continue their job. Other, what will happen if means resolution professional or any CoC and any resolution plan is not approved, okay, and survival is not possible, then what will happen? Company will go into liquidation. When company will go into liquidation, then it means ki we will company business will be closed down. So what will happen in that case? Just a moment. Okay. Strengthen institutional credibility. The IBC is administered through institutions like NCLT, IBBI, insolvency professionals, CoC. A fair balance of interests enhance the integrity and legitimacy of these institutions, which is essential for maintaining rule of law, investor trust in the insolvency ecosystem. Means IBC is administrative. There are so many institutes involved in this: Educating Authority, NCLT, NCLAT, and also IBB is also there, and registered insolvency professional and liquidator, okay, is also there, and CoC, when any resolution professional appointed as the IRP, so then he is responsible to constitute a CoC. CoC take wisdom decisions. So means, so these are the the stakeholder. These are the parties involved who ensure to enhance the integrity and legitimacy of these things, which is essential for maintaining rule of law and investor trust in the insolvency ecosystem. And last one is alliance with constitutional and global principles. Balancing interest, IBC aligns with Article 14 of the Indian Constitution, right to equality, and international best practices such as unilateral legislative guide on insolvency law, which stress the need for a fair and efficient insolvency regime. Okay. So means these are the these actions and these codes and means are also aligned with the our main article, Constitution of India as Article 14. Also means says right to equality. Okay, and also this rule also aligns with the international law, unilateral legislative guide. So it means now what is the conclusion? What is the significance? We can understand the principle of balancing stakeholders' interest is not merely procedural. It is a note of foundational to the IBC spirit and success. It ensures that insolvency law functions not just as a recovery tool, but as an instrument for economic justice, enterprises preservation, and credit discipline. As the insolvency regime continues to evolve, maintaining the balance will remain crucial for its credibility and effectiveness. Okay, so that now we have understood what is the meaning, what is the significance. Now we will go through the what are the limitations. There are also some limitations under the IBC code. Now, what are the limitations? While the IBC code 2016 was enacted with the objective of balancing the interest of the stakeholders, in practical, several structural, procedural, and interpretational challenges have emerged. These limitations affect the effectiveness and fairness of the stakeholders, balancing mechanism in insolvency resolution. Unequal representation in the committee of creditors. The CoC, which plays a central role in approving resolution plans, consists only of financial creditors, leaving operational creditors without any voting right. This exclusion, okay, as you know, only financial creditor can be the part of the CoC, okay, and means they have the voting right only. They don't include operational creditors. Means they cannot do the voting. They don't have the voting right. Okay. So when they don't have the voting right, so then what will happen? So that's they cannot means more impact whatever decision is taken care by the CoC. So this exclusions the marginalize the interest of operational creditors, employees, and other unsecured shareholders, creates an imbalance where commercial decisions are made without representation of all affected parties. Okay, means as you know, there will be more 18 financial capital will be there, one representation from operational writer. Okay, So means what will happen in that case? The other parties are not the part of the CoC meeting. Means operational guider, employees, and other unsecured shareholders. So then what will happen? Means in CoC, financial decisions are only taken by means only decisions are taken by the financial guiders. So there may be chance. There may be chance they will not. They will take decisions as per the interest of the in the interest of the financial guiders. Okay, if this decision is okay as per the IBC code, so then what will happen? That decision cannot be, court cannot be interfered. Okay, in normal circumstances, that general statement we can say that CoC is responsible for to ensure means balancing the interest of the shareholders. That is okay, but when another parties are not the part of the CoC, so then all the decisions priority will be given by the financial guiders for to see themselves. Okay. Over reliance on the commercial wisdom, although the Supreme Court in multiple rulings, example K. Sridhar, SR Seal, CoC of SR, Steel versus Vishnoi has upheld the primacy of the CoC commercial wisdom. This sometimes result in over reliance on commercial wisdom. Means this statement is related to the CoC. Ignoring fair and equitable treatment of dissenting or non-financial stakeholders judicially difference even when outcomes appear biased or exclusionary. Okay. Inadequate protection of operational creditors. Operational creditors often receive very low or negligible payouts in the resolution plans, despite the crucial role in maintaining business operations. The code mandate fair and equitable treatment, but doesn't specify quantitative benchmarks for what constitutes fairness, mechanism to assess if operational characters are proportionally treated compared to financial characters. Okay, so this is also part of the limitation. Government dues treated as unsecured. Okay. Statute dues owed to the government authorities, GST, income tax, are also treated below secured and even unsecured creditors in the waterfall mechanism under section 53. Okay, as you know, there is a waterfall mechanism. Every claim is given the priority. Means priority means there is a ranking. First ranking will given to this, first, second this, third this, fourth this. So means whenever we are considering government dues, so these are also covered under the means unsecured creditors. Okay. So this is also the limitation. The government also earlier what was happening in earlier Rona, the preference was given to the government dues. So due to this, what was happening? The revival of the business was practically not possible. So then government decided ki if we will recover first and survival is not possible. So that is not the interest of the public, that is not in the interest of the economy of the country. So that's why they have taken decision implementing IBC code. The government dues will be unsecured and ranking will be down. Okay. Now, as per earlier code, earlier act, the ranking was means there was a priority in to pay the government dues. Now, paradigm shift. Okay. So now, as per IBC code, the means priority to pay government due is not a primary and ranking is given under the unsecured creditors. And these are also not secured under the category of means when we are talking about the government dues. Now, limited role of employees and workmen. Employees and are key stakeholders but often have limited say in the resolution process. While their dues are given priority in liquidation, they are not part of the CoC. Lack avenues to influence decision affecting their job security or pending payments. Okay. Definitely, when they are also not the part of the CoC. Okay, they don't have the right. Okay, only one workman can represent. So then they also that person also don't have the authority to means give vote, so then what will happen? That, that stakeholder will not be able to influence decision taken by the CoC. Okay, so that will also impact on the job security or pending payments. Okay, so that is the limitation. Okay, because every stakeholder is not participating in the CoC as compared to the financial character. So that sometimes somehow means there are chance and sometimes happens priority is not given to the other stakeholders. Lack of clear guidelines on balancing interests. The court speaks for balancing the interests of stakeholders principle, but doesn't define. Okay. The court speaks of the balancing of the interests of stakeholders primable, but doesn't define how such balance is to be achieved, what principle to follow when different interests clash. This creates subjectively an inconsistency in resolution plan approval and judiciary review. That is very important. See, in IBC primable, clearly mentioned the objective is also the balancing interest of the stakeholders. But how it will achieve? What principle we will follow? So on that part, somehow IBC code is silent. Okay, but it doesn't define in detail. Okay, now delays and inefficiency in resolutions. Although the code prescribes a 300-day limit, okay, many cases extended timelines due to litigation, procedural bottleneck, or lack of buyer. Prolonged proceedings diminish asset value. Aggravative disputes among stakeholders lead to erosion of trust in the IBC framework. Okay, see, CIRP is to be completed within 180 days in case it can be extended maximum up to 330 days. Okay, but in many cases, practically, it is taking much time. Okay, the code objective is defeating due to this. Okay, why this is happening? Because sometimes there is a more litigation, procedural bottleneck, lack of buyers. Okay, so these are the things also impacting to complete the CRP process in due time. Okay, so if this thing happen, this is also means reduce the confidence of the guiders and also within the stakeholders. Okay, so that are the major limitations of this IBC code, which means sometimes creates problem to complete the CIRP liquidation in due time. Okay, and also difficult sometimes to ensure the balancing interest of the other stakeholder, because only decisions are taken here by the CoC, and in CoC only financial characters have the voting right. They can influence the decision. So that is the main reason. Okay. Now, limited participation of small stakeholders, small characters, minority shareholders, vendors, and other non-institutional stakeholders often lack legal knowledge and representation, are unaware of their rights under IBC. The result in passive participation and uninformed acceptance of resolution that may be against their interest. Okay. Now, conclusion of limitations. While the IBC has revolutionized insolvency resolution in India, achieving true balance among stakeholders remains a work in progress. The structure of the code and its implementation practices is currently favor large institutions, writers, sometimes at the expenses of smaller yet vital stakeholders. Addressing these limitations through legal reforms, better implementation, and judicial oversight is essential for a more inclusive and just insolvency design. Okay, so these were the major limitations. Okay, that is creating problems. That are the main hurdles to ensure the balancing interest of the other stakeholders. Okay. Now, coming to another point, those assuming importance. Okay. Why it is important or not? Is the question. Balancing the interests of the stakeholders under the IBC involves a multi-dimensional legal framework that extends beyond the code itself. Several provisions of the IBC and other allied laws assume critical importance in achieving fairness, transparency, and equity in insolvency resolutions. These laws and legal doctrines collectively guide how competing interests are addressed in a corporate insolvency process. IBC code, what are the key provisions we have already discussed? Clearly objective, balancing the interests of the stakeholders and maximize the value of the assets. Definition is given. Section 520, 521 definition of financial and operational items is given. Section given sign 7, 9 and 10. Okay. Who can means submit the petition. Operational means financial character under section 7, operational character 9. And demand notice given under section 8. And corporate debtor can submit the petition under section 10. Section 12, time limit for completion of resolution process 180 days plus 90 days. Formation of CoC. Okay. Section 21. Section 32. Requirement of resolution plan must provide for the payment of debts of operational character. Okay. And comply with the applicable laws. Section 31, binding nature of approved resolution plan on all the stakeholders. If resolution plan is approved by the CoC and there is no violation of any section under the IBC code, adjudicating authority will also approve. When CoC and adjudicating authority will approve the resolution plan, so that resolution plan will be binding upon all the stakeholders. So then, any stakeholders or any party of the stakeholders cannot come and raise any question and means submit anything against the resolution plan with the adjudicating authority, because if there is no violation under the IBC code and if the resolution plan as per the provisions and rules and as per sections as per IBC code, so then and also approved by the CoC and also after that approved by the adjudicating authority, that will be binding upon all the related stakeholders. Okay. So then what will happen? Then payment will be done according to the waterfall mechanism in liquidation, once distribution priority among stakeholders. Okay. Distribution of funds will be done as per the priority is given as per section 53 of the means under the liquidation waterfall mechanism. Okay. So that was the law importance from the IBC code. Now coming to the Companies Act 2013. Okay, we will also understand. Section on operation and mismanagement helps address grievance of minority shareholders and directions who may be adversely affected in insolvency. Section related to audit, financial disclosure, and mispresence used in assessing the conduct of directors during CRP. Okay, so now coming to this Contract Act 1872, governs the validity, enforceability, and obligation under the various commercial contracts entered into by the corporate debtor, important in determining claims by operational creditors, vendors, and lessors. There is also another act give the importance for this IBC code. These law assumes importance in protecting the interests of employees and workmen, particularly in the event of closure, retrenchment, or unpaid wages during CRPO liquidation. Section 25F pertains to compensation to workmen during business transfer or closure. Under the Income Tax Act 1961 and Income Tax GST, treatment of statutory dues, tax claims by government authority which are considered operational debt under IBC. Okay, so these are called means considered operational debts. Means government authority also will have to submit their claims just like the operational creditor. If operational creditor is submitting their claim accordingly, if there is any tax due, so all the government authorities will have to submit their claim as per is under the category of the operational creditor. Judicial interpretation has held the government dues are subordinate to secured creditors. Section 53, Ghanshyam Mishra and Sons, in this landmark judgment also misclarified. The government dues are subordinate to secured creditors. First payment will be given to the secured creditors, so then payment will be given to the unsecured creditors. Okay, and government dues will be considered under the category of operational creditor under the unsecured creditor. SABI, when the corporate debtor is a listed company, SABI regulations ensure protection of minority shareholders and transparency in disclosures. Important in resolution plans involving takeover, delisting, or restructuring. Okay. Now, from the SARFAESI Act, while these acts empower secured creditors to enforce security interests outside court process, once CRB begins under IBC, a moratorium under Section 40 applies, overriding recovery actions under SARFAESI or RDFI. These laws emphasize the shift from individual enforcement to collective resolution under IBC. Means when moratorium starts, as you know, so then no legal case can be filed because moratorium starts, so then the resolution under the IBC code will be finded out. Okay, if survival possible during CIP, then okay. If not possible, so then liquidation. So that's why after moratorium starts, whosoever stakeholder party will participate as per the IBC code. If that party is operational creditor, so then they will submit their claims accordingly, and financial creditor will also get their money as a secured creditor. Okay. Now, there are recent amendments. We can also discuss in shortcut, because as you know, process is going on, and recent amendments comes on time to time. Okay, there is also need to change means as per requirement. The government also doing and changing and also doing amendments, because it's also mentioned in preamble also amendments as per the requirement will happen. Okay, in this in IBC code. So recent amendments related to what the important recent amendments we will discuss. Recent amendments relating to balancing the interests of stakeholders under IBC, pre-packaged insolvency resolution process PPIRP for MSME 2021, applicable law IBC code Act 2021. So that is the amended. There is amendment and under the IBC code chapter 3A section 54A to 54P, purpose address insolvency of MSME in a cost-effective, time-bound and stakeholder-sensitive manner. Silent feature, debtors in a position with creditor in control. Existing promoters continue. Okay, the beauty of this amendment is this: if there is a MSMEC organization is there, so then existing promoters will continue to manage, but CoC must approve plan. Okay, promoters will continue to manage the business. Okay, but CoC will approve the plan. Okay, pre-negotiated resolution plans reduce time and litigation. Value preservation avoids assets erosion due to formal CRP delays. Shareholder benefits, employee and workmen continued operations, preserve job, operational conduct, clear disclosure and minimum payout rules. For motors, MSME get a chance to revive business with the creditor's consent. Okay, so what is the impact of this amendment? Ensure early resolution, prevent liquidation of viable business, and protects jobs, vendor payments, and character interest. Okay. Now there was another amendment 2022 and 2023 highlights so match update resolution applicant. Okay, whosoever will submit the resolution applicant must clearly disclose treatment of each class of stakeholders. Okay, they will submit the form match, so they will also clearly disclose the treatment of each class of creditors, means for financial creditor, operational creditor, employees, government. Justification required for any differential treatment of similarly placed creditors. Okay. RPs must certify that all stakeholders are treated fairly and equitably. Impact, prevent arbitrary discrimination among creditors, strengthens operational creditors and employees visibility in the resolution process. Aligns with judicial standards set in ISAR 13 and Swiss ribbons. There was another important amendment. Introduce stricter timeline for secured creditors who wish to enforce their right under the Section 52. Enhance transparency in asset sales during liquidation to prevent undervaluation. Emphasizes compliance with Section 53 waterfall for orderly and fair distribution of liquidity assets. Stakeholder impact. Protects employees and unsecured creditors by reducing delay in value realization. Ensure value priority to government dues and wage claims. Okay. Now coming to the recent amendment, another recent amendment. Supreme Court ruling, Ghanshyam Mishra and Sons. What was the key ruling? Once a resolution plan is approved under Section 31(1), all claims not included are extensions, including statutory dues like GST. That is very important point. Okay. When we are working as an insolvency professional, okay. So sometimes what was happening? There is a, because we have to maintain what was happening. Please, that is a time-bound manner. We have to complete CRP and liquidation. If we will not get the claims in time, so then how will we resolve? So then how will we be able to complete all those things in time-bound manner? So that was a very challenging. Okay. And now coming to the statutes, if government is not submitted, for example, if the government authority has taken time, for if they were in the process of assessment, okay, assessment is done after the deadline of completing the just a hold. Okay. Then if government authority taken time, so then what will happen? That claim should be considered or not? Okay, as per judgment given by Honorable Supreme Court, that is very clear and crisp, and that is also very important. Okay, if any claim is submitted by any authority after the deadline, okay, will not be accepted, because that was the duty of the department to submit the claim in time. If that they have not submitted their claim on time, so then then there is a problem at the end of the government authority. Okay, so now we can understand very easily, once a resolution plan is approved, okay, if any claim coming, so then that claim will not be considered that, although that claim is submitted by the government authority, means by income tax authority or GST authority. Okay, what I want to say, when company was in CRP, okay, so there was a deadline to submit the claim. Okay, so then company decided, already calculated that is the amount of the claim. Okay, and resolution plan also submitted by the resolution applicant, that is approved by the CoC. Okay, and when now CoC has already approved the plan, and also authority also approved, the adjudicating authority also approved the plan. If any claim is coming, then government authority says it takes time to do the assessment. So then there is a problem of the government department, government authority. As per IBC rule and regulation, they are not entitled, they are not eligible to submit their claim in case if they miss the deadline, or if any resolution plan is approved, so then no claim will be considered. That is the very landmark judgment and very important from the insolvency professional perspective. Okay. Now, stakeholders impact. Promoters certainly and financially for resolution applicants and financial guiders requires government stakeholders to be protective during CRP to protect their interests, reinforce balance between creditors' right and resolution plan sensitivity. Okay. Now, there is another framework of avoidance transactions. IBC Circular 2023 issued by the IBBI. Resolution professionals must identify and report prevention if there is any preferential transaction, if there is any undervalue transaction, and in the influence of fraudulent or extortionate transactions more systematically and early in the process. Stakeholders benefit. Protects creditors and stakeholders value by reversing illegitimate asset transfer or siphoning by promoters, helps equitable distribution by recovering misappropriated assets. For example, if these type of transactions happen, to then resolution professional will means apply for reversing these assets, and they will he will or will take that asset in their custody for the purpose of the maximization value of the organization, or for the purpose of equitable distribution by recovering misappropriated assets. Okay, so that related to this type of transactions, circular issued by the IBBI in 2023. Proposed amendment in draft IBC, that is under consultation. Proposal level to stakeholder balance. Cross-border insolvency framework based on unilateral model law. Group insolvency provisions for consolidated resolutions of interconnected companies. Expansion of PPPI IRP framework beyond MSMEs under evaluation. Greater voice to operational guidelines, CoC decision making suggested in IBBI discussion paper. What is the potential impact? Cross-border and group insolvency reforms will benefit international creditors, multinational companies, and joint ventures. Increasing operational creditors participation will help address current imbalance in CoC voting rights. Okay, so these were the recent amendments related to the IBC code. That is also very important from the point of view of balancing the interests of the stakeholders. Okay, so that is these amendments. Actually, as the insolvency professional, we need to update ourselves with for recent amendments. Okay, now what are the key takeaways? MSMEs, PPIRP for MSE in 2021 provide time-bound, low-cost resolution and operational continuity. That was the impact on the stakeholder balance. Transparency IBB regulations 2023 requiring explicit disclosure, means in this disclosure, resolution applicant will submit the form H and confirm how will he give the equal treatment to financial creditor, to operational creditor, to other stakeholders. And in case of there is inequitable, so then he will also justify what is the reason. Liquidation to improve fairness in asset valuation and water fund distributions. tax and government dues with the help of Ghanshyam Mishra ruling given by the Supreme Court. We understand avoidance actions, IBBCI circulars, okay, prevent unjust enrichment, restores diverted assets to stakeholders. So these were the latest recent important adjustments for the purpose of balancing the interests of the stakeholders. Okay. Now, conclusion. The IBC framework continues to evolve. IBC framework continues to evolve in favor of more inclusive, predictable, and equitable resolution system. These recent reforms reflect the shift from a purely creditor-centric approach to a balanced mechanism, because earlier, as I told you earlier, means in our earlier act, the main focus was on the creditors. Now, the, means that paradigm shift. Okay. Now, our scientific approach to a balanced mechanism that acknowledges the role and rights of the operational creditor, MSME employees, government authorities, and promoters, thereby promoting long-term stakeholders' confidence and economic revival. Okay. So that these were the recent amendments. Okay. Now coming to the role of insolvency professional, that is very important. Now, our main area, key, what is the role of the insolvency professional? What is the role of the CoC? Okay. As we know, as we discussed also earlier also, the resolution professional is only a facilitator. Okay. He cannot, means commercial decisions are taken by the CoC. Okay. He can only facilitate. Okay. He cannot take means decision on the basis of CoC. Okay. Only decision will be taken by the CoC. Okay. And when CoC will take decision, whether it's related to the approval of resolution plan, so the CoC is mainly responsible to ensure balancing the interests of the stakeholders. Okay. But he is also the part of this process, insolvency professional. So he is not directly responsible, he is also responsible because he is a facilitator. Okay. He is to ensure means fair process as per the IBC code. Okay. But mainly directly responsibility is the CoC. Okay, now insolvency professional and liquidators are central figures under the IBC framework and work as a facilitator. Okay, while an IP manages the CIRP, the same or another individual may be appointed as a liquidator. If resolution fails, both roles demand neutrality, transparency, and commitment to balancing the right and interest of the stakeholders. Okay, now what will be the role of the insolvency professional or liquidators? Statutory basis, role, relevant provision, IP, insolvency professional. Section 16, 17, 18, 20, 23, and 25 of the IBC liquidator section 34 to 54 of the IBC regulatory insolvency and bankruptcy code. Ethical guidelines, IBBA model code of conduct for insolvency professional. Role of insolvency professional, management of corporate data during CIRP. Take control from the suspended board of directors. That is the role. Manage the company as a going concern, protects and preserve the value of the assets. So that is the role. Okay. So he is working as a facilitator. Okay. But how he is also responsible, we will discuss. Constituting committee of creditors, verify claims of financial, operational, employee, and government creditors. Okay. When he is dealing with the claim of the operational creditors. Okay. He also need to ensure balance of the stakeholders. He will not do any injustice. He will, if he is getting any claim, if he is rejecting any claim, there should be a base. Okay. He will also responsible to ensure means equal treatment for claim as per the means company or business policy and as per the rule and regulations of the IBC code. Okay, so in that manner, he is also responsible. But when we are talking about the balance of the stakeholders' interest, so then only decisions are taken by the CoC. So then that's why CoC is responsible. CoC can means act in that direction to ensure the interest of the stakeholder. Verify claims of financial employee or government guidance. Ensure that CoC is properly constituted and function. Conduct of the CRP process. Invites, evaluates resolution plans. Ensure compliance with Section 32. Minimum payments to operational guidance. Compliance with laws. Fairness. Places plans before the CoC for approvals. Ensuring stakeholders' equity. Make sure similarly situated guiders are treated. Make sure similarly situated characters are treated equally. Okay. So that's why he is also ensuring means equitably treatment. Highlights any unjust or preferential treatment in resolution plans. Communicate transparency with class of characters. Identification of evidence of transactions. Detect and report fundamental, preferential, undervalued and exceptional. Okay, transaction to the NCLT. If these are type of transactions he found, then he will means as per this act, he will submit the report in time frame manner with the educated authority and action will be taken accordingly. Okay. So in the, means if he will means do this act means as per the law, so then what will happen? The fair treatment can be done with the other stakeholders, because if these actions are taken, so then companies maximization value can be increased. Okay, so if this thing will happen, to then what will happen? That will also help us to maintain the balance of the means interest of the stakeholders. If CRP fails, role of creditors. Just give me 1 minute. Now, if CRP fails, role of liquidator will come into the picture. Once liquidation is ordered under Section 33, the RP becomes the liquidator, or new IP is appointed. So then what will happen? Custody and control of the assets will be taken by the liquidator. Take exclusive control of all the assets of the corporate data. Form the liquidation estate under Section 36, claim verification, financial creditors, operational creditors, employee, workmen, government authority, and shareholders. Prepare a stakeholder list and make it public. Asset sales and value maximization. Sale assets through public auction or private sale. Avoid distress sales and maximize realizable value. Okay. Distribution of proceeding under Section 53, which earlier we have also discussed. So what will be the priority? Insolvency resolution process post. Workmen due 24 months plus secured creditors. Employee dues 12 months, unsecured creditors, government dues plus remaining secured creditors. Okay. And any remaining debts, equity shareholders. This is the waterfall mechanism. Payment of distribution of proceeding will be done under this priority. Okay. So when this is already mentioned in this act. So that due to this, equal treatment is possible. Okay, for all the stakeholders. Stakeholders balance ensure that employee corporation characters and government authorities are paid before equity shareholders. reporting and transparency, files periodic reports to NCLT and IBBI, ensure the process is fair, transparent and time bound manner. Okay, so these are the stakeholders. Okay, when insolvency professional liquidator is dealing with the financial matter, that it means ensuring fair voting rights and plan evaluation. Operational character ensure minimum payouts and fair treatment. Employee workman prioritize dues and protect employee during CIRP. Just hold on. If she give me some time, I will call you after 5 because I'm taking session. If I'm taking session, I will call you after 5. Government authorities include and address statutory dues. Shareholders, promoters prevent undue control or unfair gain. Resolution applicants ensure compliance with the law and fairness to the all the creditors. Okay, so these are the means activities done by the insolvency professional, and this also when he is dealing with these stakeholders. So if he will do or justify their work or their activity in fair manner, so that is also come under the preview of the balancing stakeholders' interest. Okay. Conclusion: the insolvency professional and the liquidator together play a crucial fiduciary role in India's insolvency ecosystem. They are guardians of neutrality, expected to balancing conflicting interests while safeguarding value, following legal hierarchy, and ensuring fair, efficient, and inclusive resolution or liquidation. The professional conduct directly determines trust in the IBC process. Okay. So that is the role of the insolvency professional or liquidator. That is also very important because if see every authority will have to work as per this act. So if everyone will misplay their role well. So then what will happen? Ultimately, it will impact on the maximization of value of the organization. Okay, and it will also increase the confidence of the creditor. So ultimately, due to this, there will be very much chance to survive the business. Okay. In case not possible, if you are going into liquidation, although you will be able to get more money, okay, maximize value, and when you will distribute the proceeds, means as per section 53, as per waterfall mechanism. So then also there will be a means fair treatment. Okay, so that means so these all things are means done only by insolvency professional liquidator. So he is also means I'm not saying he is mainly responsible, but he is also are responsible for their areas to ensure to maintain the balance in the interest of the stakeholders. Okay. Now we will also means discuss role of the CoC. But I think we should take 5 to 10 minutes break. You want to take break for 10 minutes?
Yes, sir. No problem.
Yes,
You
sir.
want to take break or not?
Yes, sir. Required, sir.
Okay, so then we will take 10 minutes break. Okay,
Yes,
so then
sir.
we'll continue 3:40. Okay. Okay. Okay, let's start. Now we will discuss role of the CoC, Committee of Creditors. The Committee of Creditors need to act in the best interest of all the stakeholders of the corporate debtor. A corporate is an amalgam of various stakeholders. Okay, it is expected to maximize the value of its assets, and consequently the interest of all stakeholders. However, it may not always have the motivation to maximize the value of corporate and or promote the interest of all the stakeholders simultaneously or equitably. Therefore, the law prescribes governs norms to ensure that a corporate maximize the value of its assets today and tomorrow and balance the interest of all the stakeholders and assign the responsibility for compliance with those norms primarily to a professional, company secretary, and a custodian, the board of directors, a corporate other than a financial service provider has broadly two sources of funds, namely equity and debt. Usually, the equity owners control and run the corporates. The IBC code, however, investigates that if they fail to service the debt, the corporate in default undergoes corporate in resolution process in CRP, and insolvency professional carries on the business operations of the corporate as a going concern. Okay, when insolvency professional is means associate or appoint as a IP for the purpose of CRP, so then he operates and works as a going concern entity on going concern on the concept of the going concern basis. Okay, when he is working as a liquidator, so then he will work for the works to close down the business. Okay, so there is a difference between basis in CRP. We go for on the basis of going concern and mainly, and in liquidation we go for the means close down the business. Okay, now CoC draws up a resolution plan that would keep the business of the corporate going on for forever. The code, as stated in the loan title, requires a CRP to maximize value of assets of the corporate while doing so, balance the interest of all the stakeholders and assigns the responsibility primarily to the IP and the CoC comprising non-related financial characters. Okay. The code maximizes the value by striking a balance between resolution and liquidation. It encourages and facilitates resolution in most cases where creditors would receive at least as much as they would in liquidation. This would happen where enterprise value is sufficiently higher than the liquidation value. Okay, in such cases, resolution preserves the maximized enterprise value as a going concern. In the remaining case, the code facilitates liquidation as the maximized value for the stakeholders. Now, this code enables initiation of CRP at the earliest, even at very first default when enterprise value is usually higher than the liquidation value. Because when company will go into liquidation, so then the value of company will be less than as compared to the CRP, because during CRP business is going on the basis of going concern. So then the means the value of the assets will be on higher side as compared to the liquidation, because when company will go into the liquidation, so there will maybe the assets may be distressed assets, because we will have to liquidate the business. So the value of the assets will be at lower side as compared to the CRP. CoC has the motivation to resolve insolvency of the corporate rather than the liquidation. It mandates solution in a time-bound manner to prevent decline in enterprise value with time, reducing motivation of the CoC to opt for liquidation. It facilitates resolution, makes a cadre of professionals available to run the corporate as a going concern, provides suspension of termination of supply of essential services. As you know, means for normal means we don't provide means suspension or termination of supply of services. Okay. Enable raising interim finance required for running the corporate sector. In contrast, the code prohibits any action to foreclose, recovery, or company is equally expected to consider and take care of the interests of the petitioner. the legislative guide on insolvency law of the United Nations Commission on International Trade Law reiterates these norms. When a debtor is unable to pay, it steps another liability as they become due. Most legal systems provides a legal mechanism to address the collective satisfaction of the outstanding claim from assets of the debtor. A range of interest needs to be accommodated by the legal mechanisms. Generally, the mechanism must strike a balance not only between the different interests of these stakeholders, but also between these interests and the relevant social, political, and other enforce any security interest during CRP, and thereby prevent a creditor from maximizing his interest. It expects that creditors to recover their default amounts collectively from future earnings of the corporate rather than from sale of its assets in the manner means what is happening. For example, if there is a secured creditor, if IBC code and company is in the going in the process of CRP, if this act says ki if that secured creditor will take that single asset, okay, then what will happen? If means the value of the total asset may be reduced as compared to the collective value of the assets. Okay, so that's why this code says ki resolution for all, not resolution for only one person. So that is the main purpose, because there are so many stakeholders involved. If collective assets value will be more, so then survival will be, chances of the survival of the business will be higher. In case if individual person will take the custody of secured asset, then what will happen? That will negative impact on the business. The survival will be difficult because he will sell this asset and recover the loan amount. Then that will also impact on the business, because in this CRP during the CRP, the motive is to run the business, to survival of the business on the going concern basis. So then the collective value of the assets will be more as the individual value of the asset. Okay. Now, in the matter of Pros International Private Limited versus Parker Hannifin India Private Limited, the Ancrate retrade, it is made clear that the insolvency ratio process is not a recovery proceeding to recover the dues of the creditor. Okay. Further, the code enables a financial creditor to trigger CRP, even preferential treatment to a creditor over others. Okay. In the matter of the Parker Hannifin India versus Pros International Private Limited, the NCLT observed the nature of the insolvency petition changes to representative suit, and this lies doesn't remain only between a creditor and the corporate debtor. Okay. The CRP regulates also provide for several balances. They allows a dissenting financial creditor to exit at the liquidation value. Okay. Because if there is a dissenting financial creditor, so the value of the liquidation value will be more. So then they will be able to get means their given loan amount value at higher side, and thereby they protect its interest many creditors. However, may not like to exit at the valuation value, and those who exit leave the enterprise value behind. These balances the interest of financial creditor inter se while titling the balance in favor of resolution. The regulations also require a resolution plan to include a statement as to how it has dealt with the interest of all the stakeholders, including financial creditor and operational creditor of the corporate debtor. Judicial pronouncements require consideration of the interest of all stakeholders in a resolution. In the matter of Pros International Private Limited versus Parker Hannifin India Private Limited, the NCLT held in these circumstances, instead of interfering with the impingement order, we remit the case to the adjudicating authority for its satisfaction with the interests of all the stakeholders have been satisfied. In the matter of the Kumar Gupta and JP Infratech Limited and others, the NCLT observed the position of the present petitioner is undisputedly of stakeholders. Therefore, the IRP appointed by this court in respect of the corporate debtor policy considerations that have an impact on the economic and legal goals of insolvency proceedings. When the fundamental aim of the code is to facilitate recasting a corporate flattering in its debt obligation, it needs to take care of the interest of all the stakeholders with equity. The CoC, which is plays a unique position of the custodian of a corporate under CRP. Again, I'm reiterating. The CoC, which is plays a unique position of custodian a corporate under CRP, has a duty to survive for resolution and through resolution maximize the value of the assets of the corporate and balance the interests of the all the stakeholders rather than one set of stakeholders. Okay, means CoC will find out the resolution for all the stakeholders, not particularly one set of the stakeholders. Okay, it may be only for financial data, one set. Okay, another set may be operational data, third set may be government authorities. Okay, means that then CoC will find out the resolution for all the same manner. For example, if any asset loan is given against secured as a secured creditor, so then if secured creditor says ki I will take this asset back, so then what it happens ki it is happening resolution for only one creditor. Okay, for particular class of creditor or maybe one creditor. So that will not solve the purpose of the IBC code. The purpose is to find out the resolution for all class of creditors. Okay, not for a single set of creditors. So that is the main aim of the IBC code. Okay, so that is the role of the CoC. That is very important and crucial role because as we have understood, only commercial wisdom decisions are or can be taken by the CoC. So that's why CoC is also responsible for maintaining the balance with other stakeholders. Okay. Now we will see what should be the approach. Then we will also go through the landmark judgments. Okay. What should be the approach during the CRP, during the liquidation? Okay, related to the balancing the interest of the stakeholders. Because if our approach is as per the IBC code and as per the rule and regulations, so then we can achieve maximize value of the assets along with balancing the interest of the stakeholders and also in time bound frame on time bound manner. Okay, in this way we can means save the interest of all the related stakeholders. Now coming to the approach to balancing the interest of stakeholders under the insolvency and bankruptcy code, especially from the perspective of insolvency professional, judiciary, legislature, and regulatory bodies. Approaches to balancing the interest of stakeholders under IBC code 2016. Balancing stakeholder interest is one of the foundational objectives of the IBC, as we have studied. As stated in the preamble, the code promotes a collective mechanism where various stakeholders, financial creditor, operational creditor, employees, government authorities, resolution applicants, shareholders, and promoters are treated fairly, equitable, and transparently throughout the resolution or liquidation process. What are the key elements of the approach? Okay. Principle-based legal framework. The preamble of the IBC explains explicitly aims to balance the interests of all the stakeholders. The code is structured to maximize the asset value, ensure creditors' democracy, promote efficient resolution, provide equitable treatment. Okay. Another approach is role of CoC. Okay. Our first principle will be on the legal framework, because we are to do everything as per the rules and regulations of the IBC code. Okay. We cannot violate any rule, regulations, and sections of the IBC code. So then, coming to the role of creditors, what should be the approach? CoC primarily consists of financial creditors. Their decisions are guided by commercial wisdom, but resolution plan must comply with the section 32. But section 32 says which mandates protection of financial creditors employees and statutory authorities. Okay. Be approved by the 66% majority for fostering collective decision making. Okay. In CoC, when any decision is taken, there is a voting right are used by the financial creditors. If any decisions are taken with the majority of 66%, so then it is assumed, it is presumed then that decision and that action is approved by the CoC. Okay. If any decisions are approved by only 50, less than 66%, then that action will not be considered as a approved. Okay. From the point of view from CoC. Okay. Now, there may be another approach, judicial interpretation. Okay, oversight and equity. Courts have also played a vital role in ensuring balance. Whenever any concern coming, if any aggrieved party can also go to the court if there is a violation of the rule and regulation and any statutory provision, any section, so then aggrieved party can definitely go to the adjudicating authority. So adjudicating authority also play very vital and important role. Okay. Courts have played a vital role in ensuring balance. As we have studied in the landmark judgment of Swiss Ribbon versus Union Bank of India, upheld IBC constitutionally and emphasized equitable stakeholders treatment. Also, there was another landmark judgment also clarified. SR Satil versus Kishore Gupta, that is also very landmark judgment. I'm very much sure you have also studied and discussed. SR Steel and Sish Gupta clarified that while CoC has commercial primacy, the distribution of proceeds must be fair and equitable. So that pronouncement or judgment was given by the Honorable Court. Whenever CoC has a commercial primacy, the distribution of proceeds must be fair and equitable. Okay. This, for example, in case of liquidation, then waterfall mechanism under section 53. Okay, proceeding will be done accordingly. Okay. The landmark judgment was given by the Honorable Court in the case of Ghanshyam Mishra versus Adulas ARC 2021. Finality of resolution plan upheld ensures stakeholders cannot reopen claims after plan approval. Okay, so that was also a very landmark judgment. So in further cases, these judgments are followed and these judgments are referred in in case of any disputes, if any concerns, so these judgments are referred in cases. There was another approach is called regulatory reforms and safeguards. IBBI has introduced regulations required clear disclosure of plan impacts on different stakeholders for match. Okay, we have studied in latest amendments. The form H was introduced. In the form H, resolution applicant will means confirm the treatment means given to the different type of writers. If there is a unequal treatment, so then the judgment, then justification will be given. Okay, then clear disclosure of plans impacts on different stakeholders. Certification by the resolution professional that plan ensures fair treatment. Okay, it will be certified by the resolution professional. Fair conduct of asset sale and liquidation distribution as per section 53 hierarchy, which we have already discussed above slides. Okay, and what will be the approach of resolution professional? Act as a neutral facilitator between stakeholders. Okay, he will work as only a facilitator, but neutral facilitator between stakeholders, collect claim, run operations, evaluate plans, ensure legal compliance, protect vulnerable stakeholders, employees, operational guidance from being sidelined. Use of section 53 waterfall mechanism. In liquidation, stakeholders' interests are balanced through an established hierarchy. Insolvency first preference priority is given to the the claim of RP, resolution professional or liquidation cost, then workman dues plus secured creditors, then employee dues, unsecured creditors, government dues, other creditors, equity shareholders. So this is means distribution of proceeds is done as under the section of 53 as per waterfall mechanism. Okay, so these are the approaches adopted to ensure the balancing the interest of all the related stakeholders during CRP or liquidation process. Okay, so means everything is important to understand. Unless until we don't know what is the definition, what is the significance. Definition means as per IBC code. Okay, and what is the significance given? Means as per IBC code. What are the limitations? What are the importance? Okay, what is the role of the insolvency measure? What is the role of the CoC? What are the approaches? Means what are the approaches and what type of approaches should be adopted by the different type of stakeholders, or who are the person responsible for to ensure the balancing the interest of the stakeholders. Although if there is any concern come, so then we can refer the landmark judgment. Okay, if we will submit unnecessarily legal case, so then court will also refer the landmark judgments. So means with the help of judgments given by the Honorable Supreme Court, by the Honorable NCLAT, by NCLT, we can easily understand and to resolve these issues and these concerns. Okay. Now, another approach is special approach for MSME. See, CRP and liquidation is okay. But for normal company, that is okay. For MSME, there was a requirement because these companies are have very means limited resource, limited money. So if in case of they want to resolve, okay, so if they want to go, if any company is going for CRP or liquidation, so then special treatment need to be given to these type of organizations, keeping in mind, because they have limited resource, they have limited money. In case if in dilution will take more time, or means for example, if resolution time is given in normal companies in under CRP, it takes really time. If it will take more time, so then company will have to pay more money for means expenses. The cost will be high on higher side if taking time. So then what it means, the cost of the resolution will be as high. So that's why in case of MSME, resolution time is given less. If resolution time will be less, so then cost of the resolution will be on less. So then their chances of revival of the business will be on higher side. So that is the special treatment given to MSME, as we have already studied in amendments. Okay, so this related to MSME, new sections introduced. Okay, so means further also, as per the requirement and amendment will be done by the government. Okay, in the interest of the economy, in the interest of the resolution process, because the purpose of this code is to find out the resolution. Okay, so whatever is the best in the interest of the economy, in the means industry, in the company, in the government, appropriate action, appropriate amendment will be done by the government authorities on time to time. Okay, now special purchase for MSME, PPA, IRP introduced to preserve viable businesses and jobs, give existing promoters a structured chance at revival with creditors oversight, encourage lesser cost, minimal disruption, and stakeholder sensitive solutions, stakeholders oriented approach. Summary: financial creditor, voting right, asset protection, plan control, operational creditor, minimum payment in resolution plan, employee and workmen, property and liquidation protecting during CRP, government authority recognizing of statutory duties, promote a shareholder limited role but permitted revival in MSME, PIRP. Because what is main difference is this: key when a normal company is going CRP, so then all the means authority and will be taken care from the existing management. But in MSME, what is happening? Company business will be run by the promoters normally, but decisions will be taken by the CoC. Okay, so that is the main difference between the normal CRP and CRP for MSME. Okay. Now coming to the conclusion. The IBC follows a structured, principle driven, and judicially supervised approach. Okay. To balance the interests of all the stakeholders, while financial creditors retain commercial control, the code ensured that other stakeholders are neither ignored nor unfairly treated. Through legislative provisions, regulatory oversights, judicial scrutiny, and professional conduct of IP, the code aspires to build a fair, inclusive, and efficient insolvency ecosystem. Okay, so that is that is the summary of I can say main line. With this definition, with this conclusion, we can easily understand the objective and who is responsible and who is not responsible and what action that's taken. Everything we can understand with this conclusion. Okay. Miss, why? See here, IBC follows structured. Okay, because every thing is given in this code, and means already defined everything. Who will be the financial character and operational character? What is the role of IRP, CARP, liquidator? and principal driven. Okay. And also in case of if there is any miss any concern, so then judiciary supervise this means process. So that is that is the beauty of this code, and it also helps to balance the interest of stakeholder. Financial writers are taken decision, okay, but they also need to take care ki the stakeholder should not ignore or unfairly treated. Okay. Now we will discuss the landmark judgment. Okay, to understand the why and how is to ensure the balancing of the interests of the stakeholders in case of any violation or any means ignorance is done by CoC or any other person or authority. So then how it is tackled with the help of landmark judgments, we will discuss and understand. These are the landmark judgments, very critical and important for the purpose of understanding the importance and what are the issues, what was the resolutions, what were the implications. Okay, so these are really helpful us, which guide us what to do, what not to do, and what will be the impact. Okay, and what is the procedure. Okay, and if procedure followed, then the impact will be this. And if not procedure followed, then impact will be this. And what will be the role of the judiciary? What is the role of the other stakeholders? Everything will be understandable with the help of these landmark judgment. Okay. Now coming to the SAR Seal India Limited. The SAR Seal India Limited is a major seal producer defaulted on loans over 49,000 crore. ICICI Bank filed an application under Section 7 IBC code before the NCLT Ahmedabad. Now, resolution professional invites bid. Okay, and ArcelorMittal emerged as the successful resolution again. Okay. See, who was financial director? Financial director was ICICI Bank. Okay, and resolution application submitted by ArcelorMittal. CoC approved ArcelorMittal resolution plan. Okay, a 92.4% vote. Okay. However, the NCLT and NCLT modified the resolution plan. Okay, when CoC already approved the resolution plan with the majority means above 66% resolution plan was approved by a 92.4% voting right. So, modified the resolution plan. Okay, why? Modified the resolution plan by NCLT on what basis? Okay. Okay, as per their opinion, the directed resolution plan must be should be based on the equal treatment of financial and operational writer. Okay, in the view of the court, the equal treatment is not given to the operational writer. Okay, allow Standard Chartered Bank a dissenting secured financial writer to be paid on par with unsecured operational writers. Okay, so that was the issue. The matter was appealed to the Supreme Court. Okay, now we will first understand what were the key issues. Okay, key issues was scope of judicial review. Can the educating authority NCLT and CLAT interfere with the CoC commercial wisdom, especially in distribution? Okay, if any resolution plan is approved by CoC, just a minute. Okay, now when any resolution plan is already approved by the CoC with majority means right. So then can educating authority can interfere? That was the question issue. Okay, means if already approved. Okay, now if in the opinion of the educating authority, the resolution plan is not fair or equally. Now, second question was equality of creditors. Are financial and operational creditors required to be treated equally in the resolution plan? Role and power of CoC. Does the CoC have discretion in deciding distribution of payments among creditors? Right of dissenting financial creditors. What is the entitlement of dissenting secured financial creditor under section 32B? Okay, so these were the issues and these were the questions, these were the queries. Okay, now what were the courts of observation? Okay, now after issue we will understand what were the courts observations. Then what was the key takeaways? Okay. Okay, what was the court observation? A commercial wisdom of CoC is paramount, means final. The court reaffirmed the primacy of CoC, especially in evaluating commercial viability and distribution. Judicial authority cannot question CoC decisions once legal compliance under section 32 is ensured. Now coming to the differentiation versus discrimination. Equal treatment is not the same as equitable treatment. Okay. Financial creditors, banks, and operational creditors are inherently different in roles, risk, and recourse. A resolution plan can treat them differently. Okay. Treatment can be different. Okay. But equally treatment. Okay, see here. As a low minimum repayment to pressure creditors, not less than liquidation value is made. Okay. Now, role of educating authority, NCLT and NCLAT can modify the resolution plan approved by CoC. Their role is limited to rechecking whether the plan satisfies section 32 mandatory requirement, section 35(1) legal approval, right of dissenting creditor, dissenting financial creditor is entitled to minimum liquidation value. Okay, value of interest, security interest as per the section 32B and regulation 38. What were the key principles, key takeaways from this landmark judgment? Legal principle, a sharp steel judgment position, CoC primacy. Okay, that was the key aways. Okay, CoC commercial decision is final and cannot be interfered unless legally flawed. Okay, we have already discussed in above slides. Final decision taken by CoC with majority will be binding upon all the stakeholders. Okay. Unless until if it means violates any rule and regulation, any section of the IBC code, so then there will be a problem. Otherwise, court will not interfere in this CoC approved resolution plan. Judicial intervention, NCLT and CLAD can reallocate distributions or questions, CoC business decisions, differential treatment allowed. Okay. Financial and operational creditors can be paid differently based on their claims and risk. Dissenting creditors, right? Dissenting must receive at least liquidation value or value of security, whichever is higher. Operational creditor protection must get at least liquidation value and the plan must be fair and equitable. No equalization of all creditors. Okay, no equalization. That is okay. Because if there is a secured creditor, reference will be secured. After then, unsecured creditors. Okay. I mean, we have to follow the rule and regulations. For example, in case of liquidation, we will refer the section 53. Okay, waterfall mechanism. So see, no explanation of all creditors. Court rejected and creates order for equal treatment among all cases. Okay. What was the final judgment given by the Honorable Supreme Court? Asset Mittal Resolution Plan was restored as approved by the CoC because CSC already approved with the majority 66%. So in that case, court will not come into the picture because court also thinks we are not capable because we don't have that expertise of the to take commercial wisdom decision because this wisdom is with CoC because financial characters can run the business. Okay, and CoC can take the means decision means related to investment. So that's why they says as per rural regulations, CoC decision taken will be the final. Okay, if fulfills the requirement of section 32B. Okay. Clarified section 32B and regulation 38 are directive, non-mandatory in imposing equal treatment. Distribution decisions lie within the exclusive domain of CoC. Quotation from the judgment: it is the commercial wisdom of the CoC that must prevail and which must be respected by the adjudicating authority. Okay. Means what we are trying to discussing this judgment, we are trying to means if there was no means fair treatment done is done by the CoC or and basically CoC is responsible, then court will come into the picture if there is any violation of the rule and regulations. Okay. So means although to ensure balancing interests of the other stakeholders is also a responsibility of CoC. But if CoC approves taking care of all the things and taking decision, that will be the final. Okay, that's why we have also discussed some of the limitations of this. Now, impact of the judgment: landmark proceeding, establishment characters, led resolution model, strengthening credit discipline by respecting financial character hierarchy. Okay, provided clarity on role of operational character, limited voting rights, but assured minimum payment, boosted investor confidence. Resolution applicants could rely on CoC decisions without court overrides. Basis for further IBC jurisprudence on stakeholders balancing judicial restraint and resolution finality. Okay. So that was the landmark judgment given by the Supreme Court. Okay. Now we will discuss the another landmark judgment that is also very important. Supreme Court judgment in the landmark case, Ghanshyam Mishra and Sons Private Limited, adults assets reconstruction. What was the background? The corporate debtor was OMML. Resolution applicant was Ghanshyam Mishra. CoC approved a resolution plan submitted by Ghanshyam Mishra under the IBC. NCLT approved the plan under section 31(1) of the code. However, statutory and operational guidelines such as Asset Reconstruction Company (ARC), government authorities attempted to initiate or continue proceedings to recover pre-CIRP dues. Okay, after the resolution plan was approved. Okay, the core issue: can creditor enforce claims that were not included in the approved resolution plan? Key issue: whether a successful resolution applicant can be burdened with past liabilities, dues claims that were not part of the resolution plan. Are government dues considered as the operational debts and therefore extinction once the resolution plan is approved? Does section 31(1) IBC, especially after its 2020 amendment by known all stakeholders, including government authorities. So these were the key issues. On the basis of these were the backgrounds, who are the were the parties, what was these things were the backgrounds, and these were the key issues. Okay, now what were the key observations given, observed by the honorable court? A resolution plan binding on all. Court emphasizes that a resolution plan once approved by the CoC and the NCLT under section 31(1) is binding on the corporator, its employees, members, creditors, government and statutory authorities, other stakeholders. The idea behind IBC is to give a clean slate to the resolution applicant. Okay, because see, when resolution plan is submitted by the resolution applicant, so CoC and resolution professional, on the basis of means details, facts, so he submit the resolution plan. Okay, so he submit the resolution plan on the basis of the information, detail provided, was the detail shared as per the IBC code. In case, for example, if we have to pay loan of 500 crore, and resolution plan submitted by resolution applicant, we will pay this loan. Okay, 500 crore. Now all of a sudden, any party, any stakeholders comes and says that was pending at my end due to whatever reason. So then, then who will bear this one? Means when resolution applicant already the plan was approved by CoC, so then who will bear that 100 crore? So that's why court, after approval by the CoC and the NCLT, so then court will give the clean state to the resolution application. Then the resolution application will be bound and responsible for resolution plan submitted by the resolution applicant, not beyond the resolution plan. Now, government dues are operational debts, as we have already studied in our slides. Government dues are operational debt and covered under the unsecured debt. Treasury dues as a tax, custom, GST on to government or local authorities are treated as operational debt under IBT. If such dues are not included in the resolution plan, they are considered extinguished and cannot be recovered later. Okay. See, earlier we have already discussed, for example, that was the duty of the government authority. If government authority didn't submit their claim in time, so then government authority, that department or that authority will be responsible for this. Means after resolution plan, no claim will be considered, and company and means responsible person will not be bound to pay any claim. Okay, so means that was the mistake at the end of the government authority. Means claims submitted after resolution plan will be extinguished. Okay, and cannot be recovered later. Yeah, I'll give you one example. For example, in case if resolution plan submitted, okay, then it's okay. Now, government authority says we have done assessment, okay, and there was a claim, means that amount is 100 crore is recoverable. Now, new management will come and new management will run the company. So then, new management will not be responsible to pay me earlier amount, because he will already get the clean slate, because the business will be given to the new management with clean slate. Okay. And he will not, the new management will not be responsible for earlier any pending dues due to any reason, whether resolution plan approved or not, whether claim submitted before resolution plan or after resolution plan. He will not bother Because if he will means take care of this thing, so then he will be in trouble, because new management will not be able to survive and not be able to run the company. In that case, that will be very awkward and difficult situation for the organization. Okay, so that is the main reason landmark judgment given by the honorable courts. Government dues are operation, that is okay, but not considered after the resolution plan. That was clear and judgment on that given by the court. Objectivity of IBC, revival, not recovery. Okay. See, also, government wants to revival of the business. If business will be closed, so then this is also not good for the economy. If company is going on, so then definitely company will make money, company will also pay the tax. Okay. In case, if we will recover, okay, if company don't have the funds, okay, if we will put unnecessary burden on the company, then what will happen? Instead of survival of the company, company will close down. Earlier means act was not means focusing to recovery part morely, instead of means reviving of the business. So that's why IBC code introduced the main intention, main objective of this code is to revive the business, not to recovery. So that's why government thinks, yeah, government thought, if government is unable to get or recover their due, tax dues, so then there is no problem. Ultimately, from government point of view, also it will be good for government side if company will revive or business will revive. It will help means to boost the economy, and in future when company will make the profit, they will be able to generate the tax on long-term basis. Okay, so that is the objective. Okay, now coming to this section 31(1) amendment clarified the position. The 2220 amendment to section 31 with the retrospect effect clarified that the plan is binding on the government authority as well. Okay, we have discussed. The court held that the amendment was clarificatory and declaratory in nature, hence even applies even to plans approved before the amendment. Okay. Means that amendment was retrospective, means it should not happen. Ki, for example, if government is submitting claim, so then that will be considered. Okay, so it should not happen. Ki if claim this question this issue raised means on 1st April. Okay, so then from 1st onwards, this issue will be resolved from this point of view. No, if there is earlier application, so that means issue and judgment will be effective from retrospect. Okay. So that was a very good landmark judgment. That was really very important, because sometimes in general layman language we also understand means if government authority is submitting claim, so then we will have to take care, because we can means ignore means operational guidance claim, but we should not ignore government authority claim. So that thinking was not means correct. That thinking was wrong. So then there was need to change this scenario, this phenomena, this paradigm. So that was the reason this code is introduced, and landmark in the landmark judgment, honorable court clearly defines and given judgment, clear cut judgment. This thing cannot happen, or this thing will be this happen, and these all things are also ensure the balancing the interest of the stakeholders. Okay, because if definitely resolution applicant is also a stakeholder. If an unnecessary burden will come into the resolution applicant, then means then we are not maintaining ensuring the balance interest of the stakeholders. Okay, so that's why these judgments are also very helpful to ensure to balance the interest of the stakeholders. Okay. Now, what was the key takeaways? Supreme Court judgment. Key takeaways was scope of binding effect resolution plan binds all stakeholders, including government authorities. Extinguishment of claims pre-CRP statute don't included in the plan are extinguished. Okay. Okay. Now, one point also comes. For example, if any company coming, we means CRP process going on and there is a resolution process means approved. Now any company is coming, we are means under the category of just MSME. So then that company will not be able to get the benefit, because if certificate taken or any action after the resolution, that is also not acceptable. Okay, because at the end of the day, resolution applicant will get a clean slate, cannot be burdened afterward. So that is the bottom line of this judgment or these issues. Okay, finality of resolutions. Once approved, no firm can allow re-litigation on enforcement of old claims. Now, what was the final judgment? The Supreme Court upheld the validity of the resolution plan approved by the NCLT and CoC. Held that adults, ARC, and government authorities cannot initiate or continue any proceeding to recover claims not included in the resolution plan. Emphasize that the resolution applicant must be protected from past liability to ensure the success of insolvency resolution. Quotation from the judgment: a successful resolution applicant cannot suddenly be faced with undecided resolution plan has been accepted. Okay, so that was the quote from the judgment. Successful resolution applicant cannot suddenly be faced with the undecided resolution plan has been accepted. Okay. Now, what was the impact? For resolution applicant, boosted confidence. They can take over business without fear of old liabilities. These suffering encourage more aggressive binding, approving recovery from debtors. For government authorities must lodge their claims timely in CRP. Cannot raise new claims or proceeding post-plan approval. For creditors, stress the importance of participating actively in the CRP process. Failure to file claims results in waiver of rights. For insolvency framework, reinforce finality and sanity of resolution plan. Prevented multiple litigations post solutions. Promoted speedy revival and certainty for investors. Background: corporate debtor Binani. Okay, now this is another case. Okay, now we have studied, gone through the two Supreme Court landmark judgments. Pardon? Okay, now we will discuss Anclate judgment in the landmark case of Binani Industries Limited versus Bank of Baroda. Okay. Now, corporate debtor was Binani Cement Limited, a subsidiary of Binani Industries Limited, defaulted on dues of 6,000 crore. Bank of Baroda initiated CRP against Binani Cement. Resolution professional received bids, and Dalmia Bharat was selected as the successful resolution applicant by the CoC. Okay. Means resolution applicant was the Dalmia Bharat. Bank of Baroda was financial creditor who submitted the application under Section 7. Corporate debtor was Binani Cement. Okay. Binani Cements Limited subsidiary. Okay. Now, later on, Ultratech Cement submit a revised offer with the higher total value, almost full recovery of for all creditors, better terms for operational creditor, a commitment to settle debts outside the CRB. The ECOC declined the Ultratech offers, citing process finality and continued with Dalmia's plan. Binani Cement Limited, the parent company, challenged this before the NCLT because now actual final decision was taken care by the COC. Okay, COC approved the Dalmia Bharat plan, but submitting another resolution applicant who was Ultratech. Okay, submitted revised offer key and they offered give they will pay all the money to all the creditors. Okay, now Binani Industries Limited, the parent company challenged these before the NCLT, which allowed reconsideration of Ultratech offer. Okay, Dalmia and other appeal to the NCLT. Okay, means NCLT allowed, but then Dalmia, who was the first applicant, applicant appealed to the NCLT. Now, this was the background. Okay, now it's really very easy to understand the judgment when you read the background, the issue, okay, the court observation, then take over, and what were the further impact implications. Now, what was the court observation? IBC is not a recovery, but for a resolution, the purpose of IBC is value maximization and resolution, not mere recovery from banks. A resolution plan must revive the company and benefit all stakeholders, not just financial characters. Equal and equitable treatment must be there. Equitable treatment doesn't mean equal payout, but fair distribution based on the role of the class of characters. Operational characters cannot be ignored. Near zero recovery with financial characters receive near full payment. Ultratech plans superior on merit. The revised Ultratech plan offered near 100% recovery for all the financial and operational items. Better compliance with IPC objectives, transparent and credible. Hence, it was aligning with the IBC's spirit, even if not initially selected through the first bidding process. The role of COC and fair play. COC decision must pass judiciary scrutiny where unfair discrimination or lack of transparency is evident. COC cannot operate arbitrarily or ignore better offers that serve stakeholders' interests. Okay. Now, key takeaway. NCLT holding stakeholders' interest. Resolution plan must consider interests of all stakeholders, not just COC. Operational character side must be treated equality. Late revised offers can be considered if the maximize value and promote fair outcomes. Judicial review allowed the COC decisions violate IBC principles, equality or transparency. Plan finality versus fairness. Finality of process is important, but not at the cost of the fairness and objective. Okay. What was the financial judgment given? Allowed alternate allocation plan, holding it superior in terms of taking stakeholders' value. Criticized the COC decision to reject a better offer. Clarified the value maximization. Okay, notable notion, the resolution plan is not a sale of or auction or recovery proceedings, but a collective decision to resolve the stress of the company to keep it as a going concern. What was the impact? Gave precedence to value maximization and equally overreached process formality for operational character significantly strengthened their rights under IBC, prevented token payouts or discrimination distribution. Resolution applicant enforce the better offer even late can be considered if value is maximized. Set expectation of fair competition and transparency. For COC must evaluate plan objectively and fairly. Cannot use process rigidity to shield unjust decisions. Okay, see here. What are the final judgment allowed alternate resolution plan? I think this we have studied with CoC. Okay, now another one is okay. Now see what happens here. There was a see here, there was a corporate debtor, Binani Industries, Bank of Baroda was financial creditor, RP, registered professional received the bid Dalmia Bar selected by CoC. Later on, it's Ultratech coming with maximization of value. Okay, so then NCLT means as per regulations means revised or rejected CoC plan. We need to consider the best offer. Then agreed party Dalmia goes to the Ancalate. Okay. So then Ancalate also given the judgment कि for the purpose of maximization of value, if anything coming delay, because in case if resolution plan approved by the CoC and also resolution plan approved by the NCLT, okay, and then later on any new resolution application is coming, then that will not be acceptable. But in this case, what was happening, CoC not considered the best means offer and also at till the time no approval was given by the NCLT. So that's why revised offer given by the Ultratech is accepted. Okay. राजनीति में 10 मिनट फोन करता हूँ 10 मिनट में करता हूँ. Now another case was judgment landmark case Standard Chartered Bank versus Tish Kumar Gupta. Okay, what was the background? Corporate debtor was SS Steel, CRP initiation under Section 7. Resolution applicant was SR Mittal. Okay, Standard Chartered Bank, a dissenting secured creditor, financial creditor holding 3,487 crore exposures were allocated only 60 crore in the resolution plan. SCB challenged the discriminatory treatment sitting in equitable distribution of proceeds. The NCLT approved the plan with modification. SCB appealed to the Ancalate. Okay. The key issue was whether CoC can discriminate, whether operational creditor must be treated equally with financial creditor. Does the commercial wisdom of CoC allows unequal payout to creditors? What is the role of educating authority ensuring equitable treatment of stakeholders? That was the key issues. Okay. Now, court objection was unequal treatment not presumable among same class. Means same class, unequal. If there is no same class, if class is different, so then unequal treatment is okay. For example, financial creditor, okay, and operational creditor, secured creditor, unsecured creditor. If class is different, then unequal treatment is okay. If class is same, within same class, so there should not be unequal treatment. Operational creditor cannot be ignored. Okay. So that was the court observation. Operational creditor must be paid not just minimum liquidation value, but also be treated equally fairly. Okay. CoC commercial wisdom, not absolute. Okay, that is not the final. Although CoC decisions are viable and feasible property, the distribution mechanism must not violate IBC principle. Okay, means CoC will have to follow the means rule and regulation of the IBC code. They can take decision, but in the preview of the means boundary of the IBC code. Okay, otherwise judicial authority or adjudicating authority will come into the picture. Okay. What were the key takeaways? And enclate equality among creditors, protection for dissenting creditors, operational creditor rights, commercial wisdom. Financial creditor must be treated equally, regardless of voting, status of size. Dissenting like SCB cannot give lower treatment if they are similar placements, because if in the same class treatment will be given, equal treatment will be given. If there is a distribution, then aggrieved party can go to the court, and court will take appropriate action under the IBC code. Operational creditor must receive equitable share, not just liquidation value. Commercial wisdom of CoC, not immune from judicial review. It's if discriminatory. Plan modification power. Enclate has the authority to modify resolution plan to ensure compliance with IBC. Okay. Final judgment and conclusion. The Enclate modified R3 Mittal resolution plan to ensure equal treatment of SCB and the other financial creditors. Ordered equity payout to all the financial creditors based on the principle of party. Directed that operational creditor also be paid equality, not merely the equation value. Emphasize that no discrimination is allowed between voting and dissenting creditors, large and small creditors. If there is a one creditor is small claim and one creditor's claim is high, so then which cannot discriminate. You will give preference to the large creditors. The amount will be equally distributed in the same class. Okay, so that is the means fair and equal treatment. Okay, secured and unsecured creditor is same class. Okay, if same class, then no discrimination will be done. If not same class, then discrimination means as per POT payment will be given. So now what was the impact of this judgment? For dissenting creditors, enclate order empowered minority creditors, ensuring they are not punished for dissent. Operational creditors strengthen their entitlement to equitable payout. Resolution applicants increase obligation to treat all creditors equitably and justify distributions clearly. For CoC limited the unfettered commercial decisions setting payout to creditors. Okay, so that was the landmark judgment given by the enclate. Okay, now subsequent developments overturned by the Supreme Court. The primacy of CoC commercial wisdom. The differential treatment is permissible among class of creditors as long as minimum legal protections are met. SC held that equity are and the CoC can decide on distribution based on class and security interest. Okay, so that was the judgment given by the enclate. Now we will discuss the another judgment. Okay, NCLT judgment. Background: Innovative Industries Manufacturer, creditor ICICI Bank Limited, default amount was 60 crore. ICICI Bank filed an application under Section 7. Innovative Industry opposed the application. It was the relieved industries under the Maharashtra Relief Undertaking Act, and proceeding IBC were barred during the substance of the state protection. Then can the Maharashtra Relief Undertaking can override the provision of the IBC code? What is the role of adjudicating authority under Section 7? How should the interests of creditors and corporate debtor be balanced in the initiation stage? Okay. So now there is a contradiction of two acts. Okay. Now, but IBC is not act, IBC is a code. Now, what was the court observation? Trigger for CIRP as objective. Okay. Whenever IBC code is coming in the picture, so then the IBC code will override the other act. Now, court trigger for CIRP is objective existence of default. The terminal implies that Section 7, the iteration, the existence of default, Maharashtra Lift Undertaking Act cannot override IBC. Okay, IBC can override the Maharashtra any act, but any act cannot override the IBC. So that was the court observation. Now balancing stakeholders' interest through IBC. The NCLT highlighted that IBC ensured time-bound resolution if balance the interest of creditors and corporate debtor. The process under IBC protects all stakeholders via the CoC. So that was the observation of the from the means Honorable Court. Means trigger for CRP's objective, existence of default should be there. So that is acceptable. Okay. If any other act will, no other act will override the IBC code. And also for balancing stakeholder interest through IBC, because with the help of the CoC. Now, what were the key takeaways? IBC trigger test. There should be existence of default. Application must be submitted with the 7 means 9, 10. IBC supremacy. IBC override the other acts. Stakeholder fairness. IBC framework ensure fairness through CoC decisions and judicial oversights. Debtors protections. Debtors right to object is limited to factual known default. Okay. Judicial review under section 7. Okay. Now, what was the final judgment given? Modified asset method plan to ensure equal treatment of SCB and other financial creditors. Ordered equally payout to all creditors. Okay. This directed the operational creditors also be paid equally. Emphasized that no discrimination, voting and dissenting creditors, large and small creditors, secured and unsecured. That was the final judgment. What was the impact? Declare a moratorium in sections 14, appointment of IRP. Okay, innovative industries, reliance on the state protection, MRU Act was invalid. Quotation, once the debt and default is established, the adjudicating authority has no option but to admit the application. Okay, so that was the landmark judgment was given by the NCLT. There is another last judgment because there was 2 judgment I given on the Supreme Court, NCLT and NCLT. Now there is a last judgment. What was the background? Reliance Communications Limited was the corporate debtor. Financial creditor was SBI. Resolution applicant was the Geo's Infocom company, and committee of creditors approved the resolution plan with overwhelming majority. Okay. Now, multiple stakeholders raised objection regarding the distribution resolution proceeds, particularly Department of Telecommunication, operational creditor, minority, secured financial creditor. What were the key issues? Whether the resolution plan submitted by Geo Group was legally valid and compliant with the section 32. Whether the distribution mechanism under the resolution plan was fair. As per section 53, can the rights of operational creditor and government creditor like DOT to be overridden by the CoC decision? Does the plan protect the interest of all stakeholders, including minority financial creditors? No. Okay, now what was the court observation? Resolution plan is compliant with IBC. Commercial wisdom of CoC prevails. Operational creditors received equitable treatment. These were the main court observation was there. Minority dissenting financial creditors are bound. Dissenting secured creditor minority banks argued for higher allocation based on the security interest. NCLT ruled they are entitled only to liquidation value of the assets, whichever is lower as per section 32B SR seal AC planning. Now, what are the key takeaways? Binding nature of if majority decision taken by the CoC, that will be binding. Operational creditor protection will be there. Government claim. DOT dues treated as operational debt. Plan distribution of will be as per section 53. Judicial review limited to ensure compliance with section 30. No interference in business decisions will be. Then court will not interfere in the commercial decisions. So these were the key takeaways. Final judgment given, NCLT Mumbai approved the resolution plan. But directed implementation of the plan and execution. All claims not included in the plan, all pending legal proceeding relating to such claims. What was the quotation? The resolution plan is in conformity with the section 32 and ensure fair treatment of the all class of creditors. Impact was, what was the impact? Paved the way acquisition of critical telecom infrastructure assets, financial creditors, operational creditors for those reform that government dues on operational tax enacted before financial creditors. Okay. So for IBC children, reinforce that the resolution plan is binding on all stakeholders once approved. Reiterate limited judicial interference under section 31. Added strength to the SL Steel doctrine on commercial wisdom and distribution discretion. So that was a landmark judgment given by the Honorable Court. So now I have, from my side, I have covered everything. If you have any query, question, you can ask. Otherwise, we will conclude the session. If anyone have any query or question, you can ask. I will request if a coordinator is there. Miss Anjali, are you there?
Sir, Anjali ma'am is in meeting right now. So myself, Chakshu Gambhir from ICS IAP.
Okay. So then we can conclude this.
Yes, sir. So thank you so much on behalf of ICS IAP and from all the participants. It was indeed an insightful session for all of us. Thank you so much, sir.
Thanks, Alok. Thank you very much. Have a nice day.
Thank you, sir.